Friday lordship is significant factors. There are three matters.
What is the matter?
Regarding promotion lordship, they are going to promote it.
Monday. Let it be on Monday. Yes, 4, 5, 6. Let 4, 5, 6 not be for me.
I think causes of course number 10, item number 33. It's a transfer matter and the returnable today and the interim order is still today.
All right, we'll take it up. You mentioned second half.
With the lordship, my lord, in this matter,
Item 10. Yes.
my lord, this particular matter I mentioned on the Monday, my lord, that I have honorable court of pleased to order for listing today, my lord. But due to change of the benches, my lord, it could not be listed. But otherwise, it has been registered yesterday, my lord. It has been filed on Monday.
Motion matters.
Motion matter, my lord. So I wait for
Which bench?
the bench three, my lord.
It will be on Friday.
But can it be taken up today, my lord? It has been already registered and
What is the matter about?
the matter is, my lord, the appointment of the Gaupura of the petitioner as Gaupura has been set aside and my order is 15/7. But that has been, he has come to know about the order only on 18/8, my lord. Immediately he has filed.
So let it be on Friday.
Any moment, my lord, his appointment may be terminated, my lord.
Today we don't know.
If time permits, my lord.
Already if time permits. Okay.
Obliged, my lord.
Notified documents are number 50 of today. Content matter.
Yes.
It may come after 3 weeks.
You're calling?
And for the petitioner.
Okay. Item 50 at the request of Mr. H. Roman. List after 3 weeks. All right.
So item number 25 and 26 of code number 10. There's some extreme urgency with the petitioner. This is a matter pertaining to
25 and 26.
26. Because the petitioner is going to retire this month on the 30th. And there is already a judgment passed by the honorable court. We reinstate it. But also and to conduct a de novo proceeding, but they could not complete. And also the person and the pleadings are completed.
Your Lordship, I know the respondent side, he was reinstated when it comes to, but however.
What is the urgency today?
Because the person is retiring on 30th.
Your Lordship.
30th. You have it on 25th.
Your Lordship,
25th, Friday.
your Lordship, I'm from the respondent side. Your Lordship, the counsel for the respondent, main respondent, she has to urgently leave for Silchar, your Lordship. She will be back on Friday evening. Or Saturday morning.
Number of occasions they have taken time also. This is the last.
The petitioner has expressed some urgency. We are directing the matter to be listed on 25th.
Your
You review your prayer on 25th or you.
Your Lordship, she had to, she's a single parent, your Lordship, and her son had a need counseling.
Madam Counsel, please understand, we are not oblivious to the difficulties faced by the council, but it is for the council to agree. If he agrees, we have no difficulty.
She is going to retire on 30th.
But she is saying 28.
Your Lordship, she will be back.
It's a Monday.
The records are with her. The records are with the main counsel, your Lordship.
I already informed the deal he has consented also.
No, we have not consented,
No.
your Lordship.
He is representing M.
She is also the counsel for responding to the
I
court,
have
your
already
Lordship.
informed he has consented.
We are not intimidated about that, your Lordship. She will be back on Friday evening,
On
so
numerous occasions also they have taken.
I understand,
Can it not be taken up on 28th? This is a Monday
Yeah, yes, your Lordship.
and she has some difficulty. So 30th, your person is going to retire.
Yes, your Lordship.
You press for a hearing on 28th.
In that case also you get the top of the list.
No problem, your Lordship.
All right, item, you mentioned it 28 at the request of, sorry, what is the item number?
25 and 26.
25 and 26, court number?
Code number 10.
Court number 10. At the request of both councils, matter will be listed on 28. For what admission?
For admission hearing.
For admission hearing. Considering the fact that the counsel for the petitioner has expressed urgency that the petitioner will retire on 3008. Matter be listed as a matter be listed at the top of the list. Matter will be on the top of the list. 28 August.
Nice to meet you.
Okay. My lord, I like to mention item number 13.
Yes.
This will be, next week.
In fact, to us,
No, next week.
why?
Because, hello, Aditya.
Item 13 at the request of Mr. So-and-so learned council matter agent for 2 weeks.
But let me mention item number 15 of the lordship, we have already taken the consent of the other side. They will come up after 10 days.
Item 15 at the request of Mr. Ganguly list after 2 weeks.
Same orders to be continued.
We don't know. Why do you want interim order?
Because lordship, we have seen that if no orders are passed, there will be, there is a stay on the departmental proceeding.
No, because if we extended the interim order, then it has to be
They will
fixed
come
on a
next-
date.
Next Wednesday, lordship.
No, what is the difficulty today?
Only difficulty is that there is some difficulty, personal difficulty with Mr. S. Bora. We have seen lordship, whenever dates are given lordship without any stay order being passed, they, in spite of the fact that the petition is pending.
Alright,
they
list on-
stay order.
List on 8th September. Interim order to be extended, interim order if any shall be extended till the next date fixed.
Yes, lordship, I'd like to mention item number 9. lordship. We have got phone number 266, lordship, and item may not be taken up today, the conducting council, Mr. V. Kanapati is not in town, lordship.
You take consent of the
Yes,
petition.
lordship. Taken up by-
Item 9 at the request of both council list after 2 weeks.
lordship, it may be put-
No, you have for the respondent,
Very good.
yes.
My please, lordship. My please, I beg to mention item number 35 of today's statement. Content matter, this matter, maybe close matter, the order has already contacted this.
You are for the petitioner,
Yes, lordship.
who's for the respondent?
And
It is submitted by Mr. M. Islam,
my lord.
learned counsel for the petitioner that the directions contained in the order dated so and so passed in WPC so and so has been complied with. Mr. S. Doctor appears for the which respondent? Respondent may on request of court I appear. No. Appears for the respondent matter stands. Since the order has been complied with, content petition stands closed. Notices are recorded. Hello. Yes,
I think for this, the concept for withdrawal.
Friday.
I need to mention one declaration of 2021 for admission problem, and on the last occasion, the responding authorities was asked to instruction, and I have asked him, instruction is there, madam.
Hmm.
So if the matter is listed in the paper, like this.
On 8th of September.
Once we make to mention in matter for orders filed on registry matter, which is not been listed minor, maybe next week minor,
8th.
eight minor. This is the obligation.
Number 42, council for the video from withdraw person with the country. Will be listed in the
Item 42,
42.
at the request of learned counsel, Mr. So matter stands adjourned for 1 week.
Lordship, I did to mention item number 17.
Yes,
Taken consent from the petition. Lordship, maybe 2 weeks time to file the article.
you are for the respondent.
Yes, responding to and 3.
Respondent,
2 and 3
High Court.
for item.
Mr. Your name
Yes,
S. Setia,
yes,
A. Setia learned counsel appearing on behalf of, on whose behalf?
you can ask.
UK9, City Council, Standing Council for the High Court prays for 2 weeks' time to file counter affidavit. It is submitted, consent of the petitioner has been obtained. List after 2 weeks.
May I please, your lordship, I will to mention for listing a RSA. For hearing.
RSA.
Matter of serious one, but
So you make a mention when the bench is available, it is only for urgent matters.
it was urgent, my lord, as the other party is trying to occupy our land.
All right, it is on Friday, it is on Friday.
My lord, we can get, maximum only there.
Why are you making a mention saying it is urgent?
So, all right, my lord, all right.
We have-
All right.
we have taken lordship. Lordship, I'd like to mention item number 33 of the daily instruction.
Yes,
This matter will kindly be taken up next week, Lordship. We have filed an affidavit in reply, Lordship, yesterday.
MS so learned counsel, here for the petitioner.
Lordship.
Submits that an affidavit in reply has been filed yesterday. And as such. The matter will be taken up next week. Registry to. Verify and conduct the additional, the reply affidavit stated to be filed with the petitioner with the. Petition, and the matter be listed after 1 week.
Okay, Lordship.
Item 36, madam. Order complied. For the petitioner.
And I heard so and so which is submitted that. The directions contained in the order dated so and so passing WPC so and so. It's been complied with. And accordingly does not wish to press the contemplation. Taking the submission in record. The petition stands, the contemplation stands closed, notices are recorded.
Make yours. One of the, your worship may not like to take up item number 456. So my query is whether it takes it.
We already passed
Yes,
the
we
notice.
pass one of, next week, my lord. That's the only one.
Like 4, 5, 6, not before we place
Yeah.
it next week.
Next week, that.
Yes,
Lordship, my case was listed in bench number 10, now it has been transferred to this bench. There is a stay matter, kindly be taken up with this, item number 38.
matters are not transferred. Only thing is that if it is urgent, then we can take it up.
It is that Lordship stay matter is involved in arbitration proceeding,
Item number
item 38. Lord.
38. What number 10? All right.
Lord.
But it will be taken up in the second half.
For imprisonment of party items 1 and 2.
None appears. None appears this after 2 weeks.
Amen.
None appears for the petition.
And
Applicant.
wait for 1.
MSMD for appears for respondent 1.
Amen.
For admission item 3.
Yes.
Matter which pertains to the recruitment of because person advertisement. But after the other day, but then matter. But then you also can have a look at the advertisement.
What is the stage now?
Well, they have kept this entire process in the hands on the basis of one circular, which says that recruitment.
Now, these are for sweepers.
Yes, these are.
So how is the bank managing without sweepers?
It is, you are working on contract basis and I schedule.
Why have you not considered the same petitioners are working on contract basis?
Some are working.
Okay.
The whole issue is whether that guideline of the logistic will have a retrospective. Because I could get the recruitment circular, my lord. It says that sweepers, part-time or full-time sweepers that could be recruited by way of a process where the selection will be through interview only. Now that has been changed. In fact, this recruitment policy has not even been implemented. And that central government notification or circular or instruction, whatever it is, came after the interviews were over. So the whole question which calls for an answer is whether that instruction will have a retrospective effect.
Where is that circular?
It is in their affidavit, my lord. Page 44 your. My lord, the one in the copy that was in page 7. May I read? I'm directed to refer to the announcement made by Sponsor to the Independence Day program, that is, I was to say that the committee of secretaries chaired by the cabinet in its meeting held 13/11/2015 recommended the continuation of interview in the recruitment process in public sector bank for union level post by the deadline of 31/12/2015. So, my lord, even the 22/12/2015 instruction says that the recruitment process to interview has to be discontinued by 31/12/2015. So this instruction apply post 31/12/2015. And before the issuance of this instruction, my lord, interviews were already open. Only prayer,
When was it held?
my lord, we have given.
When was the interview held?
In the review petition we have given, for this present persons are concerned, my lord, their interviews were held. Concluded, so far as the petitioners are concerned in this petition, interviews were held, last interview was on 21/11/15. In one branch, it was 3/6/2015, in one branch, it is 9/6/2015, 14/9/2015, 16/9/2015. So, my lord, interviews were all over before issuance of this circular instructions. And my lord, out of these 19 branches, interviews in 2 branches were not held because within the cutoff date, no applications were received. This fact we have brought in the review petition, my lord, where this honorable court was pleased to consider all these facts and review that earlier order of 3/6/2022 and posted this matter for fresh consideration. So, my lord, it is an admitted position that interviews were over before this 22/12/2015 notification or instruction was issued. So the prayer before this honorable court by the petitioner is to just for a direction for declaration of the. Whoever is selected. Is selected.
See, this is an advisory by the government of India.
Yes, sir.
But an advisory by government of India will have the nature of perhaps some binding effect on the stakeholders, including the banks.
Yeah.
Now, reading this advisory, it is seen that there is a process to discontinue the interview and go for alternative methods.
Discontinue by 31/12/2015.
Correct. So by 31/2015 means by 31, if any interviews have been held, you discontinue all the process. By 31/12/2015, does it mean that those interviews which are held up to 31/12 are not covered? Or does it mean that whatever steps you have taken to proceed for interview, you abandon all the process by 31/12?
My understanding, my lord, this is an instruction. Now, my lord, the question is whether the instruction will operate retrospectively or prospectively. My lord is aware on the last date, I have taken some decision which says that any amendment in the process or rule will always be prospective unless it is made retrospective by
Is
the,
there a set of rules?
they have a recruitment policy.
Where is that policy?
My lord, I could get their super, my lord, this is a policy of 2007. To my instruction, these are still in force. and they have not amended or changed this policy.
Yes,
Now, the lordship will see, the advertisement is very clear, my lord.
no, we are with you, that advertisement was there. This notification has come in 31/12/2015 is the cutoff date. My only question to you is this deadline of 31/12. Is it to be interpreted that by 31/12 abandon all the process, or by 31/12 whoever has undergone the process will not be affected? You want to interpret
My
in
understanding is-
obviously, in the favor of saying that by 31/12 whatever has been undertaken will not be affected by the notification. But the language of the notification is not that. Language of the notification is the discontinuation.
My lord, may I once again read, in the meeting held on 13/11/2015 has recommended discontinuation of interview in the recruitment process in public sector bank for junior level post by the deadline of 31/12/2015. So, my lord, my understanding of this language, you have to discontinue the process of selection by interview by 31. So, post 31/12/2015.
No interviews.
No interview.
Correct. But discontinuation will be with effect from 13/11. Discontinuation,
My lord, this continuation, then lordship, they were also given a direction. Accordingly, it has been decided to advise all those to necessary action. which-
when were your interviews held?
My lord, so for this.
Interview was held on 11/9/2015.
And 2015. 2015,
11/9.
11. And my lord, this.
At that time, the decision was not taken by the board, and accordingly, it was put under review.
Now, if the bank wants to go for the new process,
They have not amended this recruitment policy. Now. Lordship, by come to the third page, it is not marked. Have underlined those mode of selection. This is the candidate will be called by sending letter to them the certificate of posting for appearing at interview on a suitable date. Selection which is made through interview only.
no, they're correct.
So, my lord, this is the policy of 2007, and this is still in force, and under this policy, the advertisement was issued. Now, even for which, under this instruction, they have not changed their policy, they have kept the entire process in effect. It is not their case,
What is your stand now?
No, Lordship, my
in the affidavit, they have stated that they have kept in effect, nothing.
No, Lordship, that the board has stopped the process, and all the banks in an Indian bank association have taken a decision to make a proposal to the ministry. Until then, the ministry has not given any decision.
The ministry has not given a decision. You have been extracting services. It is convenient for you.
Yes, sir.
You are extracting services from them on a contractual basis. Then
That is our problem, so.
there's no problem. You are creating the problem by yourself. Where is the problem? There is you have a policy. There is a decision taken by the finance department. Either you obviously cannot stick to this policy now, post 31/12. So you have to bring in a new policy. Once you bring in a new policy, you decide what you want to do with the petitioners, whether you want to go for a fresh process of recruitment. You have not taken any stand.
Your Lordship, our stand is to put the matter in again because of this not taking of the decision, and it is taken by all the banks. Because the circular is.
No,
not
then
only
don't
for-
employ them, then don't employ them. Don't employ the sweepers. Don't employ them. You don't want to take a decision, don't employ them. You have found out an easy way for exploiting the petitioners. You are not giving them the employment as per your policies. You are keeping them on a contract basis. Doctrine of pleasure.
My lord, in the last occasion, I have based on decision of 1990, to say, you may have a look at the decision of 1990.
putting up an application before the ministry is not the way to. The ministry has already given you the advisory. You now have to take a decision.
My lord, all this person who had applied in 2014, I just can forward it. So my lord, the answer which requires or decision is whether this instruction will have retrospective effect. Because my lord,
This question would have been easy to have been answered if the petition was filed. When was the petition filed?
in the year of 2018.
So if the petition was filed around that particular time, you see now what has happened is, it is difficult prima facie to accept your contention that till 31/12/2015 interviews can go on by reading this. That interpretation I cannot adopt. That till 31/12/2015, whatever interviews are there, you carry on. After that, no interviews. That is what your interpretation is.
The other interpretation, my lord,
The interpretation which I get by reading this prima facie is by 31/12, we have to stop everything. But the decision has been taken on 13/11/2015 to abandon the regular process of the process undertaken by interview. And 31/12 is the outer limit by which everything must be stopped. And thereafter you go for the fresh selection process, which they have not done.
my lord, in that case also, even the decision, when the decision was taken, interviews were held. So that ultimately the question which requires an answer from a lordship is whether that decision will have a retrospective effect, because there is nothing indicated in the instruction that the interviews which were held earlier will also have a bearing of this circular. Because,
Yes.
my lord, the law which I have understood, my lord, any amendment of rules is always prospective unless the amendment makes it clear that it will have a retrospective effect. This is.
So there's no dispute on that. See, this is an advisory. This is an advisory showing that the process of interview is not accepted or not acceptable. Discontinue it.
So can
Go
it
for
be, my
fresh.
lord, have an impact on the process where interviews were already held?
See, interview, the process of interview selection by way of only interview vis-a-vis a process of selection by written tests, psychometric tests, etc. Are basically, these are two different processes for screening of suitable candidates. So naturally, candidates will prefer to stick to interviews because psychometry, written tests, the screening
End
being
of
board.
the day, who are the persons they are selecting, my lord?
That's all right, but you are
My
not
lord, they are selecting sweepers, part-time, full-time, my lord.
correct, but this policy, are you challenging this policy?
But it is, when this policy, my lord, in my understanding, when this policy doesn't apply to my case. Because the decision was taken, even assuming, my lord, on 13/11. Then also the interviews were over. And there is nothing in the instruction which says that it will govern the pending recruitment process.
See, the problem here is, this is not only in respect of your clients relatable to Indian Bank. What is this Indian Bank?
Yes.
Now, earlier it was
Allahabad Bank, or Indian Bank. This is a position perhaps in all banks.
Yes.
So the relief that you're seeking for will have a cascading effect and will result in nullifying this,
No, my lord.
may have the effect of nullifying this recommendation.
My lord, here the interviews were over. The recruitment process was initiated in 2014. interviews were over before coming into effect of this instruction. So the question is whether this instruction will have effect on the interviews which were already over. Now, had this instruction not been issued, how to have declared the result?
What is the process by which what is the process of the bank in changing their policies? You are required to now, how, supposing you want to go for the new process of recruitment, how will you do it? Only on the basis of this advisory or by effecting a change in the policy?
Not simple, that decision will be taken up by the boards only. And as for the event, my lord,
And so far as the contract employees that you are taking up, what is the policy? On what basis are you engaging the contract employees?
daily wage basis, daily wage basis,
On what basis?
no basis.
What is the policy?
I have to bring before your council.
You can't decide to abandon the policy and then go for something which is not a part of the policy. Because it is convenient to you.
Even after 7-8 years, my lord, they have not come up with a stand that they have changed the policy.
Yes,
So they have kept the entire process in events
you get,
for an
you
indefinite.
get these instructions.
Yes, sir.
We'll take it up on what, Tuesday or Wednesday, Friday, not Friday. On some Tuesday, because this will require some hearing, no matter. We can have it on 12th, if you want. 12th September,
Can it be in this month, my lord, because these are poor people, my lord, this report from 2014.
or 31st August. Thirty-first. Mr. S. Chakraborty appears for the petitioner, Mr. N. Sharma for the respondent bank. Mr. Sharma seeks some time to complete the instructions and advice report. An address report in respect of the present policy adopted by the bank for recruitment of sweepers on contractual basis. And also whether any amendments or modifications have been brought into in respect of the policy regarding recruitment of part-time sweepers in banks pursuant to the advisory from the Government of India. Ministry of Finance, dated December 22nd, 2015. List on 31st.
Item number 7,
31st.
But wait for a week's time to find my affidavit. Actually, yesterday night I got my instructions not to appear. I think that got this. My God, 22, 13, 22. Before justice, 30, my manager friend was taken time. The relief software has been granted, also. The seniority will be counted from the date of joining. I just want to place it nine affidavit.
Why place it on affidavit? If the relief has been granted, what is the point?
Not you can dispose it off. We are part of the report.
Are you sure it has been granted?
That's why Lordship, I will place it in the form of an affidavit. Lordship, 2 days time will be fine, Lordship.
MS R. Mora, then Standing Council, Agriculture Department submits that instructions have been received. Should like to, I'll bring it on record by way of an affidavit within a week's time. MS B. Chaudhary, Learned Council appears for the petition, does not object to the prayer made. List after 1 week. List on 8th of September.
Item number 8.
Yes,
Not this matter really.
covered.
Covered,
What happened to the appeal?
no, the FDI has flagged me up with no development is there.
What happened to the appeal?
While of the dispose of, whatever the outcome, that will be followed.
So is there any interim order? Has the hearing been concluded?
Lordship, can it be taken up later, Lordship?
Why are you not posted with the instructions? Taking it up later poses difficulty in the flow of the matters. All right. We'll just keep it aside for the time being.
Item 10. Item number 10.
The appealing for Agricultural University.
This case matter, it's now already retired from something.
No, last time we had granted time to
Yeah.
file affidavit.
Yeah, and that's a matter, I will be ready, but because of retired from timing, now what has happened, I have seen the prayer also. That basically their case is there, my lord. There are challenges, there are two parts in the prayer. One prayer is my regarding. They want to set aside the selection of the pilot. The 4 to 7 men. And another is my lord. To consider for appointment of for both promotion to post of grade 3. And also to keep consumer ratio of MACP. What happened, I had, because I got to select the minutes, the CD joined the selection process, madam. But he got less marks, he got total marks of 53.5 marks. Ultimately, he was not selected. Whereas respondent number 5 had shown in the selected also the minutes, how much mark they have got. They have got much more marks than him. Now, so now question is that he is entitled for promotion by law, because there he is holding an isolated post of laboratories. It is an isolated post, my lord, and there is a recommendation for giving promotion, my lord, on 2-scale promotion, but that is already entitled. Another promotion is also entitled, my lord. That was common pay committee was constituted, my lord. He said that if he gets that promotion, he is to be satisfied. So let me take instruction, my lord. If the common pay committee gives recommendation, then he will get it, my lord.
Mr. P. Potoki, Learned Council appearing for Agriculture University submits that the petitioner has in the meantime retired. And as such, there are some instructions we'd like to obtain from the department in respect of the claims made by the petitioner, therefore raised for 2 weeks further time. Mr. Moiso, Learned Council appearing for the petitioner, does not object to the prayer name. We list it after 2 weeks.
Yes, kindly.
List after 2 weeks. The list on 11th. 11th.
Item number 11.
Yes.
In this case, also the record shows that previous final reply to my affidavit. But I am not having that reply also. To expect this any day proceedings, it's not certainly copy of that.
You have not served a copy.
Probably it was probably served also by this case, not in my time.
Matter be listed again on 19th September, 19th. Is submitted that the pleadings in the matter are completed and therefore matter be listed for admission hearing. 19th.
Item 12.
I seek tonight accommodation for 2 weeks. Madam. The petitioner have to come in, take instruction whether he wants to file a reply, otherwise, my lord,
What is the matter about?
my lord, the petitioner is a UV inspector, constable who wants my lord promotion to the post of DSP by direct, and seeks a direction from this honorable court to the home authorities to hold the special, mode of examination. My lord. There's a rules are there. My lord. It is last held in 1992.
At the request of Mr. D. World, matter stands adjourned for 2 weeks. Mr. Sarma Guru appeals for his comments.
Item 14.
I think economical instructions is exact concerns, additional exact concerns.
What was the prayer?
Prayer was not to be. Addition is of addition safety. Addition security we was. And after publication of the gradation list, so the DPC has everything great and promotion has also been had.
He has been promoted.
Also,
Petitioner has been promoted.
the petition has been promoted, he was not recommended by the solution committee. We have filed affidavit to that effect and enclosing the.
You are for the department. You are for the department.
No, I am for the private responder.
Who's for the department? Water resources. Who's for the water resources department?
Taking some. Visually to some your there.
That appears for the petitioner.
Earlier opinion to have of the clear course. And person has declared themselves,
He's retired.
declared. They are no longer interested in.
Let us have the presence of the standing council at least.
I can call it those.
We call
After
the,
something, after something.
yes, okay.
Item 16.
That means.
This is a case for selection to the post of revenue selector. The deputy commissioner's office not by.
Yes.
So if the biddings are complete, all the department has filed affidavit. And it is affidavit position that nothing is selecting for a post of the commissioner was not as in accordance with law. And merit also and the better position. Possible can you say here, but as
We will take it up for hearing then.
I am going to declare.
When?
2024,
24.
24 January.
Enough time.
Otherwise, he will be benefit of it, since 2019.
All right. It is submitted, meetings are completed. Learning councils for the partners. Yes. Matter be listed for admission hearing on 28th of September. 28th of September.
Item 18.
Yes.
This case relates to the matter decision of the seniority matter from the FPSP list matter. And a promotion for DCM. That promotion part, we are not on that, my lord, during pendency of the case, we got the promotion. To that effect, my lord's identical nature of the, this honorable court has disposed of the writ petition, my lord, 4294. Lordship kindly permit me, my lord, to supply the copy. In that line, my lord, let them decide, my lord, let them do fixation, my lord. On the basis on my seniority position, my lord, my name appears at lordship will see annex 1 at page, my lord.
Well, this has to be tagged with one other petition, my lord, whole seniority exercise is in put for all, because my lord, there are some anomalies in the rules, my lord.
No, we are not up to that, my lord.
Yes, he has to-
Well, decision, my lord, let them decide, my lord. Why they are clubbing this matter with another matter? The simple case, my lord. They have to last last 2-3 paragraph this statement. It is already been decided. For that line, my lord, 4 to 8.
You are employed as what?
My lord, now I was the SDF, now my lord, pendants of the case, I got the promotion of this year. So promotion part, we are not insisting. Now, my lord, on the fixation of my seniority, I want to. And below me, my lord, there have been given.
That has to wait, my lord, that has to wait.
And from my lord, 2023, that's the last, my lord, that is not a file. They are counter affidavit, my lord. Now they are seeing, my lord, tag the matter along with the other piece here. The photos. The one I was thinking about it. I could be. Totally at the beginning. Already.
I am not wrong, my lord, subject to correction, and order is nothing about, my lord, has been, my lord, reviewed. 4294, my lord. 4294.
4294.
Yes, my lord. Yes, my lord.
Is it been reviewed?
It has been reviewed, man. Did you order it?
No, I ordered.
Yes, yes.
Yes, my lord. Yes.
Review from what the students.
This review is my 109 of 20.
And look on that.
This is the thinking, my lord. This is the parallel, just review. And my lord, all is, my lord, hanging the fate of, my lord, order 6723 of 13, my lord.
Well, 109. Which
20.
20. 20.
Reviewed. Your order has been, the judgment has been reviewed.
But anyway, my lord, I am entitled, my lord.
And
We
my
don't know,
lord,
these matters are directed to be listed along
yes, my lord. And
some matters, so
6723.
if you are relying, if you are submitting that,
I'm not relying on that, my lord.
just rely on this
My
order.
lord, I submitted a copy, my lord, in this line, my lord, that case can be disposed of. Now it has been said, my lord, it has been reviewed. Now, my lord, only my prayer, my lord, is that, my lord, at this stage, if your lordship club with the other cases, my lord. The pendency of the case.
We are not saying, we don't want to club it. It is you who submitted that this matter can be disposed of because this issue has been settled by this order.
Hold on.
Now, if it is settled by this order and this order was subsequently reviewed, in the review order, this matter has been taken along with some other matters.
So this matter also may be club, my lord, only one observation be given. Pendency of the case may not be part for them, my lord. So,
I declare council in this one, so this is submitted as the part that similar the issues have been urged in other petitions, and they have been directed to be clubbed together by coordinate bench. Accordingly, with this petition, we also listed along with WPC number 4942, 4948,
6723, madam,
6723.
and 1148. 6723.
Is it 4294 and 4942? Two different matters.
Analogous, madam, 4294 and 4.
Then and 4294. When are these matters fixed?
Well, it has been fixed after 8 weeks, madam. Department has been, since when there is some anomalies in rules, madam. The department is finalizing the rules, madam, to live under the defenses.
All right, be listed along with so and so matters.
When from pendants of the case, madam, cannot be barred.
Pendency of the case shall not be a bar for
Consider.
consideration of the prayers of the petition.
Alright.
Item 19.
19 my lord pertains to discharge from service. But the duties are otherwise exceed, my lord, the law is also recently well laid down by the apex court, my lord, in Amarendra Kumar Pandey's case. Then I don't see that the central government council with him, Mr. Pengu was a case. See there. Can it be posted for admission, my lord, on some other day, my lord?
Right, none appears, Mr. B. Patel appears for the petitioner, none appears for the central government. This writ petition has been filed challenging the discharge order against the petitioner, by which he was discharged from service as a rifleman under the Assam Rifles, from the Assam Rifles. It is submitted that the pleadings are completed. The matter can be listed for hearing.
Because given the admission column, the issue is not, my lord.
It is submitted that what is that issue?
Well, this basically whether overrating increase, my lord.
What increase?
Incorrigible offense has to be, my lord. Drawn, my lord. That is what the apex court says.
Sorry,
That one has to be an incorrigible offender. That is, your offenses have to be repeated. That is only when, my lord, you can get discharged from service, my lord, as per the apex court's guidelines that are given in or in the Kumar Pandey's case. That is the only thing that is to be.
letter comes in from the petitioner subjects that the question involved in the matter is whether petitioner falls within the category of being considered as incorrigible offender to enable the respondents to discharge him from service. He therefore submits that the matter be listed for admission list on 28th.
The next week thereafter.
Next week thereafter is not a good time for giving.
8th, my lord, I will not be available.
We said 28th,
28 of September.
28th, right?
28th of September.
My lord,
Yes.
my lord.
Item 20.
By this application, one of the challenge, the simple not on dated 2019. Whereby inflicted the punishment upon the petition of other. Or without the work with him and the people not are just paid. what had happened was that in this case, an FIR was lost by one under the family against the petitioner. Pursuant to that FIR, one of the departmental as well as the criminal proceeding was initiated against the petitioner. And the departmental proceeding and the criminal case based on the identical and similar set of facts. Even the charges in the departmental proceeding as well as the criminal proceeding are the same. And witness also, them had been examined. And subsequently, the petitioner was acquitted from the criminal cases. From the criminal case, he was acquitted, but the departmental proceeding imposed the punishment despite the communication of the same judgment of the honorable trial court, the punishment is for purpose of the one increment.
Yes,
Same set of facts.
there is no strict bar for that.
Yes, but no bar, but the evidence and the set of facts is same well. If honorably acquitted by the trial court, then the departmental proceeding is automatically.
Automatically.
No matter the, this honorable apex court has already given some judgments in this area. So can you see the FIR, FIR is at page 24. And the relevant photo is at page 26.
Yes.
With due respect, I have the honor to report you that the IM Mumbai University India and posted in account branch at your office. In respect to series so and so, currently posted in CIW, what he has been trying to get into a relationship with me since the time he has posted as the reserve officer in Iran DA. On the night of 13/5/2018, he came to my house with his family. He again came to my house at around 8 p.m. on so and so alone and tried to keep me for secret, to which I objected. He asked me to go on where with him, and at this I ran away from my room. As I am 6 months pregnant and knowing fully this fact, he said that I look very pretty even in my pregnancy and asked me to start it over. And the
Where's the inquiry report?
inquiry report is at page 44. Conclusion is at 60. The inquiry report based on relied on the witnesses, same witnesses has been examined in this trial. The well of the trial court is at page 16. The relevant portion was at page 74.
Yes.
Page 74.
Is what you say?
Also, we can see the deputy opposition, there are number 13.
Para?
There are number 13.
Respondent 4.
I can't also question of previous person.
Ah.
It will be good.
Yes.
There are number 13.
Yes,
That's regard to the development made in paragraph 11 of the petition that the following excuse stated. It is a fact that the petitioner has preferred an appeal before the appellate authority against the order caused by the disciplinary authority. And accordingly, the appellate authority forwarded the same appeal to the judicial department for their use. And judicial department citing the case Naresh Kumar versus State of Rajasthan. Viewed that the standard of proof in criminal cases is quite different than in the departmental inquiry and followed by the views of the judicial department. The appeal petition filed by the petitioner was rejected by the appellate authority. Hence, considering all the aspects of the matter and the fact that charge of serious misconduct proved beyond reasonable doubt against the deliberate officer, the governor of Assam has pleased to dispose of the appeal petition by rejecting the claim relief for by the petitioner and was pleased to afford the punishment of scoffers of one increment with cumulative effects caused by the disciplinary authority. Your lordship may see case number or sheet. Also may see the inquiry report that will be annexed with the affidavit of person method. The next page is the list of witnesses that we have examined with the departmental visit. There, number one, Vibras IPS, one are also these are collected.
he's relying on GM time,
Yes.
Lordship.
so you have to come out of it.
Being is the motion, we have to see whether there is 100% tally with the judgment or by the trial court and the departmental proceeding bench. And what if there is a
What, where is the your judgment of the trial court?
When a judgment of the trial court is at page 16.
You see,
The legal portion is page 74.
and where, what are the charges in the DB?
Charges in the DB page 27 minutes. Sorry, madam, page 34. That the allegation of charges, madam. 35. As stated in the FIR, the same has been given there. Then of the FIR.
So in fact, the cross examination mentioned in the judgment, and not finding two witnesses, also that is Vibras IPS and Pavitra Kumar Nath. Other these four are there.
Malati, there is no relevancy, Malati, Jubaras and the Govindo Kumar Nath, he was the SP of the set.
Then if there
The statement, if we go through, Malati, no relevancy, the entire punishment has been imposed on the basis of the 3, 4 and 5. Malati. Let upon the witnesses. Which were relied in the judgment. Same witnesses.
the cross of Vibras IPS is there case number, the next case, number one. He is the, in fact, he is the PWQ. He is the witness number one.
Yes. And regard the one that Jubaras,
The heard counsels to the parties, this matter pertains to discharge, is it discharge? What is the punishment?
punishment Malati, stoppage of 1 increase.
Stoppage of one.
Cumulative effect.
Cumulative.
The challenge to the punishment pursuant to disciplinary action, disciplinary proceeding taken against the petition. Meetings are complete. The matter can be listed for admission hearing. 26th. 26th September. 26th September. For admission hearing.
Item number 21. Yeah.
Yes,
Compassionate appointment matter, petition as the wife of the deceased husband matter, who died on 14. Now, the DLC has recommended matter, but thereafter nothing has been done.
yes.
In this case also, we have not filed our affidavit delay.
Hmm?
We have not filed our affidavit delay. Because the thing is that as far as the effort is still there.
The what is still there?
Effort was it because 2 times we can place it after that there, if there are no vacancy, the effort goes to, so the effort is still there. So let us place this case to say in the next SLC, because SLC takes up twice every year also. So if there are vacancy also, this case can be considered also. Yes, and the event lost that, lost for the direction. Of placing it on matter for the next SLC.
Very hard, well, council. Another similar over votes. Some people know only the places for SLT. All right. Petitioner's father,
Husband,
husband expired on
4/12/2014.
where have you stated? 4/12/2014.
Yes.
While he was working as a grade 4 in the office of the Joint Director Health Service, leaving behind the petitioner and 3 children. So petitioner thereafter filed an application seeking compassionate appointment before the competent authority. The application was filed on 3/3/2015. Her application was placed before the DLC Hailakandi and by its meeting held on 2003/2018. DLC recommends the name of the petitioner for appointment on compassionate ground as a grade 4 employee. So. Thereafter, no information has been received by the petitioner as to whether the state level committee had considered the case of the petitioner in view of the recommendations made by the DAC. So, in spite of several representations being filed, in spite of representations filed, no such information has been received by the petitioner. Stop. Being agreed, the present writ petition has been filed. Mr. Sarma Puru, learned counsel appearing for respondents number 4 and 5, and Mr. D. Gomendu for respondents 1, 2, and 3. Submits that they are yet to receive instructions in the matter. So having heard learned counsel for the petitioner and upon the meetings on record, it is seen that the representation preferred by the petitioner is stated to be not stated to be still pending before the competent authority. So, in that view of the matter, this court considered it appropriate to dispose of the petition at this stage, directing the respondent authorities, more particularly the commissioner, health. Who will place it? Commissioner.
Commissioner Secretary.
Respondent number 1, Commissioner and Secretary, Government of Assam Health and Family Welfare, to place the recommendation of the DLC in favor of the petitioner for appointment on compassionate ground, before. Not recommendation, the proposal for for appointment of the petitioner on compassionate ground, and which has been recommended for appointment by the DLC, before the next SLC. Stop. The SLC will thereafter consider the matter and pass appropriate orders in the proposal. Stop. Any such order that is passed, copy thereof shall be served on the petition. Stop. The matter be placed before the SLC within 30 days from the date of receipt of the certified copy of the order. When is the SLC meeting likely?
Let's have to.
60 days. The SLC will thereafter consider the matter and pass it to Congress. If no order in the meantime had already been passed, if any order in the meantime had already been passed, the same copy thereof be furnished to the petition. The petition stands disposed of in terms of the hearing.
Time being item number 14.
Cease for the petitioner.
Yes, what do you say?
Lordship, this matter has been instructed. Would you like to address this?
When it comes to the parties, it is submitted that the petition has become infructuous. Therefore, the petitioner does not wish to press the petition any further. The same accordingly stands dismissed. Interim order referee stand vacated.
Yes, sir.
Item number 22.
Yes, these are matters from the conflicts, really doesn't.
It is submitted by the counsel for the petitioner that the matter has become infructuous. Petitioner does not wish to press the petition any further. Accordingly, the petition stands dismissed. Interim order referee stands vacated. Mr. Goswami appears for the respondent. Please close.
Time being item number 8.
Lordship, they are going to let another. Lordship, the matter is pending.
Still pending.
This is the last one, Lordship. This is after all the matters should be like.
It is submitted that the writ appeal preferred by the state being writ appeal number 287 of 2023, which is preferred against the judgment and order dated
31/22.
3001/2023, passed in bunch of writ petitions, where the leading case is WBC 1646 of 2021 over. Is pending before the division bench. Accordingly, the presented petition stands deferred for 4 weeks. Placed after 4 weeks.
Item number 23.
This matter relates to non-payment of petition of family tax matter. So the petition already got the release clause. Land council for a petitioner requested to place the case becoming faster. It has not come due to this favor finding.
It is submitted by Mr. The Landed Council appearing for Accountant General,
My lord, respondent fine.
respondent number 5. that the prayer made in the writ petition has been considered favorably by the respondent department. The special pension, what has been done?
Revision of special family.
The revision of special family pension sought for by the petitioner has been allowed by the competent authority. Is there any order passed? We have a copy of that order. (28,621).
Next one is my lord original.
Or
For lordship, due to some date was wrong. That is why that's why we put the original.
by communication dated 28/06/2021. The it's issued by the senior accounts officer, office of the principal accountant general. To the treasury officer, the full treasury. The special family pension. The revised special family pension has been released in favor of the
Petitioner.
in favor of the petitioner, who is the widow of late Bidhan Nikti, ex-Gram Sevak. Stop. In that view of the matter, nothing, no further cause survives in the petition. Also. The learned counsel for the respondent submits that this has also been communicated to the petitioner, to the counsel for the petitioner, who has also expressed who has also expressed no objection for the matter being placed before the court. Taking the submissions on record made by the learned counsel appearing for the accountant general and retaining a copy of the same communication dated 28/06/2021 in the case report with this court. Upon due consideration of the submissions made and upon perusal of the instructions placed, consider that the relief prayed for by the writ petitioner has been granted by the concerned department. Accordingly, writ petition stands closed.
It is 12 July 2020.
Yes. We will have to keep a copy of this
My lord.
communication.
My lord.
Writ petition stands closed. Yes. Mr. Nayak appears for respondent Q&As. S. Kemprai, MSS Kemprai appears for respondent. 7, 6 and 7. MS G. Bora appears for respondent 1 and 2. Anyone else? Mr. Sharma Bora appears for respondent 4.
Item 24.
This is related to.
Emily? Pension matter, yes. Pension has not been paid.
Husband was there. They worked in a coaching employer.
Husband,
Family.
item number,
24.
Kamal Bora.
No.
Yeah. Believe. Sorry. I think some confusion from the registry. Your file is not available, some other file is. Huh? We can take it up in the second half. We'll call for the file. Take it up in the second half.
Item 25.
For requirement on compulsion in ground. But other we should.
Yes. What happened?
Lordship, as per last order, the petitioner is should submit the application of this matter.
Original copy.
Yes, that's what we are looking
Where is that original copy?
at. Best, 20 party and party and 14.
So what is the status in?
Lordship, the receipt, there is no receipt in our lordship and it is not visible. Lordship.
No, do you have the instructions?
Lordship, I don't need instruction, Lordship.
Uh,
And I would like to file an affidavit, Lordship.
what do your instructions say? What does it say?
It says that the DBS rejected its standards force Lordship. As per point 7 of the 2019.
So this application has been received.
No, Lordship, it says nothing about this Lordship.
No, but how will the DLC consider unless there's an application?
Lordship, it is for this petitioner Lordship. It is for the petition.
Application was lodged for his mother. The mother has filed an application. The query of his honorable court.
And they are additional over minor.
The petitioner at that time, he was minor Lordship. And when he submitted his application, it is not, it's after when many years Lordship. So it's spent its force.
The submission of now the petition is filed by whom? By the son.
Yes, Lordship.
Where is his application?
His application is rejected Lordship because it's
Dated 19.
Huh?
On it was the June 19. The nature for.
19.
Father died in 2008 and he filed his application rejected 9/7/19 years. The petition was rejected.
19 is higher secondary mark sheet. Where is the application? Or not, and therefore you were asked to bring the application.
Yes, yes, right, he rejected his application.
You bring it on record.
Lordship.
Third learned council for the parties, MS, sorry, your name again. Theatre of the learned council for the respondents and Mr. Upadhyay appearing for PWD irrigation. The submits that instructions will be necessary and be permitted a short date to file their affidavits. At least after 3 weeks.
Yeah, that's Lordship.
Item 26.
Looks here, the issue is, my lord, the petitioner is supposed to be promoted from JDA to UDA. And some private restaurant in the state, and he included the petition. Now, the department has, they believe that the personal posts are promotion is not, my lord, allowed. My lord, here, my case is that in 2007, my lord, selection test was held. And in selection test, the petitioner has been selected to fill up the sanction post of grade 3. And accordingly, she are working in grade 3 post since 2007. Now that is why, now whether this will apply applicable or not, that is the issue. Because through selection, the petitioner has been occupied or promoted to the grade 3 sanction post. So next further post is grade 3. Then
Now,
UDA is,
now, why this is considered to be personal post?
that is previously she was working in 86. She is the competent person. She is discharging the minister, my lord, work. So my
You show me your appointment order?
Page 29 of the petition. Second, the posts are personnel of the incumbent concerned who are holding the post. And will be able to check on is the concerned incumbent she will be separate in any way.
This is your, what is the judgment of the division?
Doctor Lordship, I have. Dilip Talukdar and.
Dilip Talukdar, yes.
my lord, this,
This covered by division bench judgment.
my lord, right, my lord, this honorable division bench in our case said that because 86 is, this petitioner is discharging the ministerial work, my lord. By that time there was a ban. So they cannot be accommodated in the vacant grade 3 post. After that, they.
Whatever the ratio of the judgment is that if you are against a personal post, there's, you can't be treated to be a part of the regular cadre.
My lord.
That is the ratio.
My
In case
selection,
of this honorable court has passed an order, Lordship, where some persons will promote him. Subsequently, they were divided, they, Lordship, they have challenged the regards from order, Lordship. This is dispute, Lordship.
Another division bench order,
This is single bench order.
so, my
on,
lord,
or relying on Dilip Talukdar.
Lordship.
my lord, page 34, my lord, 32, this is not challenge, my lord, 32. This is the 28/6/2027.
Yeah, the petitioner was Lordship promoted, but subsequently he was departed back. And he has challenged the reversion order.
I mean, here, my lord, there is a, this is what the notice, my lord, they have taken a decision that we have conducted selection. So here, last line, my lord, newly promoted, that this a petitioner, they also given the chance. So at that time, this was not challenged anybody. So next, the minus kindly come page 34. And the private restaurant who has challenged this and withdraw subsequently, he was also part of this selection process. So this is something different now, that is why.
How can it be different? Your appointment order says you are appointed in a personal post.
I mean, that is-
Unless you want to challenge you want to distinguish on facts that division bench order is not applicable, then the most we can do is to
no matter division, I want in my case. my lord,
directly register to places before
Yeah.
the chief
Page
justice.
68 kindly see, my lord, this is a division bench order. Basically, last, I just want to see from your.
68.
Yes, that's what to say. Accordingly, we dispose of this appeal with a direction that state may either initiate a fresh selection. But either selection may, they have the liberty to cancel the either selection process
Now,
or
what is this issue about?
take. Our promotion was challenged, madam. And then we make appeals, then there's division bench, madam, justice. Can they change or justice, or take a decision of regulation. So this was also there, my lord, and why they cannot take, cancel the selection or take a decision, because for 30 years.
Kindly read the judgment, tell us what is the judgment.
Yes. The first judgment is simply, honorable signature judgment is starts at page. page 45, my lord. Whatever, my lord, when we are given promotion by selection, some master road workers who are not skilled, they claim that it should be seniority, come male. So they challenge this master road worker, and they succeeded in the repetition. The report, honorable report says that you revert back them, and through seniority, not through selection, through seniority, you adopt the sanction second post. So against that, this petitioner preferred appeal. But in this case, my lord, significantly page 57, my lord, this petitioner, this particular page 58, my lord, 58.
Here the
and-
question of whether you are in a personal post or you are in a caterer is not the issue here. It's not considered.
Yeah. So 58 says that they have no challenge to my pay, 40, my lord. Paragraph 90, 58, my lord. So my promotion is never challenged by anybody. Even 14, promotion of the private personnel 14, 15, so and so. So round of this is have not been challenged. So 14 is, I am the 14, error is 14 in repetition, it is not challenged, so court has not interfered on evidence. I am working in this is 2017, but after that, some similarly civil person preferred appeal and appeal. This honorable division bench of this honorable court observed that if under the fresh selection or regulation considered regulation, they cannot do it because there is no skilled labor or nobody is there. So administration will be collapsed. This is the page 70, my page 69, my lord. This is communication. It says that if you revert back, then the established will be collapsed. So they expected their service, my lord, and their regulation is not, my lord, interfered till now. Now they imported the idea that personal post, my lord, it was long back. They should not promote on selection, that should not be held. Look at this.
Does not deal specifically with this issue. But yes, these people were also master role workers and they wanted promotion. In this case,
Yes, because then they are given chance, but they are not skilled, my lord. They have no assembly degree or typing like that, so they cannot be reverted back, so nobody is to replace them after that.
no, but what do you say with regard to the judgment?
My humble judgment, with my limited understanding is that one selection procedure is there, we can't play selection. It's not that directly were promoted. And it's due, that was not interfered with or challenged, my lord. So we are continuing for last 17 years in that. So now this honorable court also given them chance to take a fresh selection or consider it.
No, we are referring to this Dilip Talukdar
Yes,
judgment.
yes, right. Whether it will come in the way or not, my lord, that I.
That is for you to say,
Yes, my lord. So I will,
you go through and tell.
yes, my lord, with like that, I.
Let them be adjourned for 3 weeks, enabling Mr. Porua to increase his instructions. Mr. Raju Upadhyay appears for the respondent authorities.
Was all right.
You should tell us, you are waiting for the court to tell you.
Yes, my lord. My,
You have to submit.
yes, I substantiate my submission, my lord. Today I have not taken. Yes.
Item 27,
Still querying this matter as per last order dated 2/6/2023, what you are supposed to place a record. Lordship, the records are furnished to us, Lordship, sir, however, somehow it got misplaced in our department chamber. Lordship, I think place the same, if Lordship allows me, every time, Lordship.
That matter, my lord, pertaining to selection for a post of laboratory technician, my lord. I cleared the written test. And my lord, the advertisements, people is that there will be a written test, then there will be a computer proficiency test, and then there will be a skill test, my lord. So, my lord, what happened is, only thing that was done is, my lord, I cleared the written test, and then, my lord, I took part in a something resembling an interview, my lord, where I was, even though the select for the post of a medical technician, I was asked questions like, what is the Citizenship Amendment Act? Such question, and then I was allowed to go. That by no definition is a skill test or a computer test. So, my lord, being agreed, I filed the. But on the last occasion, records were approving produced.
Records regarding
Regarding,
The process. They would somehow. Otherwise, mostly we have filed our application, we have stated that it was done in accordance with law.
by the last order, the respondent counsel was directed to produce the reports. Dr. Mr. T. Upamanu, learned counsel appearing for the respondent department submits that the reports have been misplaced. However, efforts are being carried on to retrieve. You, if it is misplaced, how will you place it?
Lordship, it was misplaced in our department. They have furnished it to our lordship on 5/7/2023.
He prays for a short date to trace out the records and place it before the court. Mr. You perfect learned counsel for the petition. Submits that sufficient opportunity was granted to the respondents to produce the reports. However, the same has not been produced. As a matter of last chance, last opportunity, the respondents are granted 2 weeks further time to produce the relevant reports. List on 11th.
Item number 28.
This matter pertains to Anganwadi worker in Gandhinagar, Anganwadi Center, Dibrugarh district, Your Lordship. But what happened in this case, Your Lordship, the petitioner, right, Your Lordship, order dated 1/7/2010 by your appointment order issued by the CDPO, Your Lordship. He was allowed to join duty, Your Lordship, that is Annexa 1, page 27, Your Lordship. Angular 27. High Court 25 roads. Merely
Yes.
to Srimati Meenakshi and petitioner, Your Lordship. In respect of service of Anganwadi worker, Your Lordship. Madam, it is hereby informed you that the selection of examination and held on 21/1/2010 under the Integrated Child Development Service Project, Dibrugarh, you have been selected to offer your voluntary service as Anganwadi worker in Gandhinagar, Anganwadi centers. If you are interested to offer your voluntary service within 7 days from receipt of this letter, you are hereby requested to inform in writing to the undersigned and from the date of receipt of the letter of acknowledgement received from you, it will be assumed that you have joined the voluntary service. For service rendered by you as a Anganwadi worker, you will be offered an amount of fees 15 break as remuneration. In case any error or mistake found in respect of service offered by you, you would be released from your voluntary services without any product intimation, Your Lordship. So as far as appointment order, Your Lordship, the petitioner accordingly joined, Your Lordship, And your lordship, the in extra 2, your lordship, the director of the social welfare, your lordship, according by communicated dated 6 May 2010, your lordship, page 28, your lordship. Directed all the district.
Yes, then what? Yes, yes.
Bank account, your lordship.
Hmm.
According to the bank account was open in the this concern, your lordship, Madam Sinta, your lordship. Now, after joining your lordship, the petitioner was returning his duty with utmost caution, your lordship. Then your lordship in 2014, from month of September, middle of September, the petitioner's minor child was contacted with disease, your lordship, and he was unable to join the duty, your lordship. That is the Annexa 31, that is the all medical certificate, your lordship. Then with due leave from the CDP, your lordship, and from authority, your lordship. That is Annexa 31, that is all the certificates, your lordship will annex.
Yes, then,
He was remain absent, then taking that advantage, your lordship. The respondent number 8 and 9 spaces in connivance with some antisocial elements, your lordship. Deprived the petitioner to join their duty, your lordship, resume duty, your harder, your lordship. Then we agreed, your lordship, there is Annexa 6, that is 54. The application was filed before the CDP, your lordship. That is the respondent number 6, your lordship. May I read, your lordship? That is 54. May I read?
yes,
The food child development project officer, project application praying for continuation of duty as worker in the Anganwadi center. Most especially that we state that today on 12/2/2016, the executive officer along with the Anganwadi worker, and in presence of child welfare officer, president office, I would like to inform you that from the day of joining of my duty with utmost honesty and sincerity, I would carry my work. I would work my duties in proportionality with other departments. I would also carry complying with all rules and regulations of the office, moreover in cooperation with the public, would carry on my all duties and responsibilities in this area, and I promise not to engage myself in any sort of disputes with any other employer. This is my humble submission before your honor. And indeed, your lordship, that is the note, your lordship, in the side of the application, your lordship, as part of the meeting held on the district social office, so as part of other instruction of the district social officer, nursing nurses are allowed to run Anganwadi workers continue work on humanitarian ground, your lordship. Thereafter also, your lordship, when there is a clear instruction from the CDPO to join my or resume my duty, your lordship, then thereafter also I have been restrained and depart to join my resume my duty, your lordship, in the concerned Anganwadi center, your lordship.
restrained by whom?
But the respondent number 8 and 9.
Why have you lodged a complaint?
Yes, complete. Complaint you have lost before the SP also, your lordship.
Where?
That is your lordship, and it's a Annexa 8, page 57, your lordship.
Then what happened after that?
Nothing happened, your lordship, nothing, no question was stated in your lordship to resume my duty, your lordship. Then what happened? It is respondent number 6, your lordship. Issued an advertisement for filling of the post of the different Anganwadi workers in the center of Dibrugarh, your lordship, and with other Anganwadi center of the state, your lordship. That is the Annexa 8, your lordship. Annexa 11, page 65. Kindly have a look, your lordship.
Yes. Yes.
May I read, your lordship?
Advertisement for the same post.
Yes, your lordship. But my limited PR, your lordship, so far the Anganwadi center Gandhinagar is concerned, still lies within, your lordship. Nothing has been done in pursuit of that advertisement, your lordship. And I have been also not allowed to join, your lordship. So my limited PR before, your lordship.
Did you file your application before the director that you are not allowed to join? Any application before the director?
I, but
Where is it? Yes, respondent, what do you say?
Lordship, we have received our instruction, Lordship, I'd like to find an.
What is your instruction?
Lordship, the phone number 6, asks to, the pensioner also to join, but, she didn't join Lordship. And, regarding the pair number 4, Lordship, the checkbook and all, it's still with the petitioner, Lordship.
I did not join because I have been assaulted, your Lordship. That's why I have.
You have been,
I'm the petitioner, your Lordship.
what?
I have been assaulted and restrained from duty, your Lordship, taking advantage of my absence, your Lordship.
So what have you done? Why have you not filed an FIR?
I have filed a complaint for SP, your Lordship.
What happened to that? What happened to that?
Did not take any initiative, your Lordship. Then I have been, filed an application before the CDPO and CDPO by the side of the, your Lordship, petition, your Lordship, allowed me to join. Thereafter also I did not allow to join, your Lordship.
Where is the FIR again?
That is, your Lordship. 57, page 57, and sorry,
57.
yes. Application seeking permission to continue service at the company number, Angana District. Mary Dorothy.
There's an application on the Lordship.
More exposure date listed is directed by the site developer possibility in IT on 2022-16 to carry on duty as a developer of the Government Government Center on the basis of the discovery at Hill on 31-2016. It also the district also office in its presence. Accordingly, though I went to continue my duty, but COT determination of which the Electronic Trade Center and the landlady, Rupa Mahato, a few other antisocial elements using field and radio, drove me away from my place of duty.
You did not mention that you were assaulted.
Drove me away, your Lordship.
Not driving you away, it's not assault.
My limited fear, your Lordship, I may be allowed to resume and.
The department says you are not resuming. Where is the question of allowing you to resume?
With some protection, your Lordship.
What protection do you want? Armed police.
Your Lordship.
You want armed police to go and join in the Anganwadi center.
It is my fear also. Being a lady, innocent lady, how can I?
You are in the wrong place. You should move to different places where you will get this by dint of your office.
Communicate, I fail, your Lordship.
Yes,
Okay, page 69, so there was an inquiry made by the social welfare officer. Here, point 2, Lordship. The second part, point 2, saying despite a long time, the petitioner was
69,
69.
69, page 69.
10th of October.
Yes, 10 to 2019.
Yes, you are referring to?
Point number 2, Lordship.
Yes.
As for the, she had run AW Avanoni center at the home of Rathingham as the demand of local public. She cited the ASCW from Gandhinagar in 2013, but as per her statement in the petition, she was absent in 2014. Despite long absence in ACW, the silent allowed her to resume the duty on this month. As dated this month, and knows this month, yes, went to rejoin in the service at this month, but the local people refused to let her join in the service as she was absent for 2 years. But if this was unauthorized leave, okay? And point number 3, okay? As part of complaint, Meenakshi Mayas, she have prayed for inquiry, but it was found that local people are not ready with her. But the office allowed her to render her services and as per the norms, PWW, Avanoni water may be accepted by.
You are appealing for whom?
I am for 8 and 9, okay, I will find my appeal.
What role do you have?
What's it? My role is I am one worker and one is. Owner of it.
Then
My role is paid limited.
why do you want to file your affidavit? What do you have to say regarding her joining, not joining? You don't want her to join.
I do not have any problem.
Exactly, you should not have. Yes, you ensure that she is allowed to join.
I want to find out.
What will your affidavit bring on record? Is there a procedure for taking action against Anganwadi workers? Do you have a set of guidelines or rules? Where is that show cause notice? But in the meantime, what happens to the center? Assuming you are proceeding against her, who will run the center?
Center is run by Roche, is respondent number 8, and our.
As per instruction, your worship, as per
What is the last part,
check.
last part of page 69.
Hmm.
The last sentence, that AWA Srimati Gitanjali Sanwal has been providing the service as per instruction of the office. She is running the center. And it has been shifted to another place.
Your worship, only to another place, only to dissuade me, your worship. That kind of the not known to your worship.
She was.
So it's by an immediate action for a long time. They can take that advantage, your worship. So it is
Where is the set of, rules or guidelines which on the basis of which you can issue show cause, etc. Where is it?
nothing even.
Had learned counsel for the parties, MS learned counsel for the social welfare, praise for it is granted 2 weeks time to file her response in respect of the contentions raised by the petition. Placed after 2 weeks. Let the affidavit come.
I think before your lordship for limited PI orders. And we allowed, I was in limited PI orders before your lordship. I am allowed to. review
How
my-
many years have you not joined?
Your lordship, as per in my record, it is from middle month of September to November, your lordship.
Which year?
2014, your lordship.
14.
Yes, 2014. But
You
after.
wait for 2 weeks. You wait for 2 weeks.
Item 29.
Yeah, teacher also. This letter relates to service level. The punishment imposed the petitioner by right of section 11 mark of CRPF Act is absolutely disproportionate. In this regard, my lord, whether under the section 11(1), the major punishment can be imposed for not in this regard. I have done for some decisions, my lord. So that day, my lord, can it be on after tomorrow so that I could place all the sanctions? Or day next week?
This is the case of what discharge.
Discharge. April or next Tuesday, we also the entire matter will hard. Matter will be admitted, pleadings are sometimes are raising the law. My lord, I'm to bring the records, I have received the records, but these are all in particular. You have to translate this. Receive the record.
Hindi.
Hindi. My lord, my only information in this case, record was column 28 for 2020, almost 1 year done.
You read it for us if required.
Yes.
If you want to translate it, you translate it in the meantime, but.
I've just received it.
So
Take photo time.
we'll have it on 19th.
Yes.
19th
Yes, 19th
September. It's on 19th for admission hearing. The records necessary in the matter shall be kept ready for perusal of the court
Take the honest.
if required. It will be made to dispose it of on the next 8 weeks.
Item 30.
Why? At the request of Mr. J. Hatiburial and counsel appearing on behalf of Mr. P. J. Swakia. Matter stands adjourned for today. Mr.
There is another repetition on the same issue matter. WBC 3603 2023 filed by the same set of advocates matter that may be tagged today.
It is submitted at the bar that matter be listed along with WPC
03 2023.
3603 of 2022, 2023. List,
I require some instruction in this subsequent matter, my lord. Let it be after 4 weeks.
then why are you asking for taking it if you have no instructions?
Because in these cases, my lord, we have taken the ground the first repetition, my lord.
Whatever it may be, if you have no instructions in the second matter, you should not pray for taking it. Unless you are certain that these instructions in first matter. List on 11th September for admission.
31.
May I please? Kindly pass over a meter for the time, my seniors.
For the day. Passed over for the day. Who's your senior?
MS said, he is in court number 6, coming.
We'll pass it over for the day. What is the matter?
WPC.
All right, at 2 o'clock. 2 o'clock.
I think 32.
During your lordship, we need to file affidavit with your lordship. Instruction awaited your lordship, and it grant us 2 weeks time to file affidavit.
Hey, when you have not received instructions, how will you file?
Yes, your lordship, that. Your lordship.
What is the matter about?
Because we will continue the declaration of a service, he was appointed as the junior engineer
Hmm.
So we need this gathering in service matters in the last October releasing superintendent matters. Because not received the means my lordship, this is the problem, my lordship also the urgency. This matter, I give the.
She is appointment order. Hmm. Yes, then.
And my lordship, because his service was renewed by my lordship, and according to my lordship. This matter, I give that in the appropriate UK.
So what is your prayer?
Yes, sir. So my matter, I am in superintendent, my lordship, in October 2022, my lordship.
You want this matter to be argued by your senior?
Yes, your lordship.
All right. The request is after 2 weeks. A request of so and so is after 2 weeks. Yes,
We will be taking the instruction, my lordship.
it is up to them. If you want to argue, we are ready to take up the matter. If you want your senior to argue, we'll have to adjourn it for a different day. Yes,
Date may be fixed.
Item 34.
you'll get a date from the registry.
Yes.
My lord, this matter came up on 24/11/21. That is pending council of the bank to time for filing the affidavit lordship. Office note that is 21/7/23 so no affidavit has been received lordship. Lordship, the petitioner, before the lordship was appointed as clerk of Union Bank of India lordship. He joined in on 25/7/1983 lordship. And his service became permanent on 1/2/1984 lordship. Now lordship from 25 to 1999 lordship,
a fire incident took place in the bank lordship. And accordingly, lordship, the petitioner was arrested. And thereafter, lordships, after arrest, no departmental proceeding was brought. And lordship, a criminal case was initiated against him, lordship. In the criminal case, lordship, the petitioner was acquitted, lordship. Lordship, from time to time, the petitioner has imposed before the bank, allowing him to join lordship. But till the age of 60 years, lordship,
He was not allowed to join.
not to allow join,
He was not suspended,
not suspended, lordship. No departmental proceeding, no
terminated,
suspension,
no
no
termination.
termination, lordship.
Yes,
Township, 2 weeks time may be given for filing.
why have you not filed it since 21? You have been granted time. You are appearing on whose behalf?
Mr. Mukesh Sharma and Sharma.
You'll have to pay some cost. What is this? You are not filing your affidavits. Man is out of a job, you're not allowing him to join.
Township, 2 weeks time may be given for filing.
Yes, 2 weeks.
Yes, ma'am.
Mr. R. Sharma, learned counsel for the petitioner, MS so and so learned.
Yes, yes, ma'am.
S.
Yes, ma'am.
Yes, been appearing on behalf of Mr. M. Sharma, learned counsel appearing for the Union Bank. Prays for 2 weeks' time to file the counter affidavit. Perusal of the order sheet reveals that notice was issued in the matter as far back as 10/9/2021. And on 24/11/2021, 4 weeks' time was granted to file affidavit. No such affidavit has been filed. Today also, when the matter is called up, prayer is made for filing affidavit. Have you received your instructions to file affidavit?
Sir, ma'am.
To complete her instructions and file affidavit. It is submitted by the learned counsel for the petitioner that he is been pursuant to a criminal proceeding initiated against him, for which he was arrested. He was arrested
Lordship,
and subsequently released,
release lordship and acquitted.
acquitted and released. He was not allowed to join in the bank, although he was not under suspension, nor was any disciplinary proceeding undertaken to terminate him. Stop considering the fact that the petitioner has been terminated. Prayer made by the bank is permitted subject to payment of cost of 5,000. 10,000, you are a bank, you can pay. Subject to payment of cost of 3,000. Cost be deposited in the legal aid committee of the High Court. Party High Court legal aid. Okay. Matter be listed after 3 weeks.
Thank you.
Supplementary list for admission item 52 to 57.
Yes, Mr. Rajgupta, what do you say? You can continue. Your
Only thing is that,
Ah.
so earlier case is concerned, in that case. That was a mistake on my part of course.
Madam, I will bear this, in this case, in paragraph 9, some other Mr. Roy. Paragraph 9 make condition
of
1094,
1094.
2021, this order is in your office.
1094. Yes,
Paragraph 9. On the facts and circumstances of this case, there appears to be no need for the court to return a finding as to whether the ratio of the case.
now
Rafiq Mukesh Gupta-
Rafiq Mashi was not gone into.
Okay. Well, actually, it was my mistake, though. In fact,
But I do have, your lordship, this the paragraph 10 of the Rapid Machines judgment.
Yes,
Page number 2015 4 334.
yes, yes. You got it.
Now. Paragraph 4,
10, para 10. Yes,
subparagraph 3,
yes,
recovery from the employees when the excess payment has been made for a period in excess of 5 years. Before the order of recovery is issued.
you are reading from para?
Paragraph 10 probably. Recognitions. 2015 4 SCC, page
334,
334,
yes,
ratio
para 10. An action of the state ordering recovery. That's the line you are starting with?
No, my judgment is with your lordship. My book is with your lordship.
No, it's.
No, it will be, it will be. It will be. No, paragraph 18.
Yes,
Para 18, subparagraph 4.
yes,
Recovery in cases where an employee has wrongly been required to discharge his duties in a higher court and has been paid accordingly even though. No. Subparagraph 3, recovery from the employee when the excess payment has been made for a period in excess of 5 years. Before the order of recovery is issued. No.
in your case,
My case, your lordship will find at page 13A, there is audit report. Page 11, page is at 14.
page number,
It starts from audit report, starts from page 13A, capital A, annexer A. 13, 13,
13, page number,
page number 13,
13,
13.
all right, 38. Yes,
It's the audit report, relevant portion.
yes,
Now, the lordship may please come to page 14 at the bottom. There is a detailed audit report I have taken. I will go through later, if so required. Management is requested to confirm the facts and figures. An action taken there may be intimated to audit. Audit note number 6 dated 25/10/2014. Now, the recovery process of recovery was started in the year 2020.
two thousand 20.
In fact, your lordship comes. Page 19.
So 2014. And recovery is started from page 19.
Page 19, no. Probably it was started before that. Anyway, page 19, 1% recovery, 5/11/2020. There is one order. Here we know the person concerned was retired. And recovery was made from his retired benefits. Pension gratuity, PLI outstanding.
He is one of the petitioners.
He is not a petitioner. Now, so far the affected petitioners are concerned, your lordship come to page 20. Onward.
And what was decided in 1094?
1094 was under an impression that you cannot make any recovery unless there is an earthquake. But let us read this judgment.
Paragraph 8, man.
By filing. Right.
Yes.
The action of the respondent under the facts and particular is not found sustainable on the facts in law. And as such, court has no hesitation to set aside the action of the respondent in affecting recovery. This much is in my favor absolutely. Affecting recovery of the money from the salary of the petitioner on account of alleged fraud committed by the respondent without disclosing before the court regarding passing any written order to the effect. Resultantly, the respondents are jointly and severally restrained from making any recovery, but already recovery has been made. Recovery from the salary of the petitioner on account of finding return in the CAG audit report dated 25/10/2014. Now, on the facts and circumstances of this case, there appears to be no need for the court to return to finding as to whether the ratio of the case Rafiq Musa Kupra would help the petitioners in any manner whatsoever. As such, the said case is left open to be decided in a more appropriate case. But the problem created by the paragraph 10. Before parting with the records, it is made clear that the order shall not preclude the right of the respondents to hold disciplinary inquiry or disciplinary proceeding against the petitioner and or from making any recovery after giving reasonable opportunity. After giving reasonable opportunity of hearing to the petitioners in accordance with the procedure prescribed. It is also made clear that nothing contained in this order shall prejudice the petitioners or the respondent in any proceeding whatsoever, which shall be decided in its own merit without being influenced by this.
So as and when any proceedings are initiated, you'll have access to it. That's it.
Thereafter, some order was passed by the authorities. Personal hearing was given to them in the month of, so I don't have any written instruction in the month of. This order was passed in the month of August. In the month of December, personal hearing was given to them and some recovery order was also given. That has to be
Not
challenged.
with respect to not. Your is correct, but not with respect to these petitioners.
Yes, madam. So far, petitioner number I remember, madam, he has informed Chiranjeev Bill. Against him, I remember his name, but if you also take her next week, I can have the instruction of that. Actually, madam, by last order, madam, Roshi was pleased to direct the petitioner to obtain instruction with regard to the actions taken by the authorities after the order passed in 1094 number.
We have filed another case,
Sorry,
they have taken some action with some other employees. And we had filed the read application, your working may kindly note out this read application. Read petition number 915 of 2022.
filed by this same petition.
No, other.
It's a different issue. Well, let me take it up then. So you're pressing the judgment of Rafiq Masih. You see that under Rafiq Masih, there's no question of recovery now,
Now,
after more than 5 years.
there are some 5 years.
Then we'll have to hear it. List again on. We'll hear it on 19th September.
And you're okay. Yes, subject to lot of convenience.
19th September. For admission hearing. Readings are completed. 19th September.
Any list for orders item 37?
Is it convenient for you, the dates? Okay, 19th September.
Well, it is lot of convenience.
It is on, any date is convenient for us. Yes.
Item number 37.
I'm looking for number 50. I remember I've been appointed.
What is the direction?
My direction was to press this hard case before the SNC at first. Because again, I think yes, I took harmony.
Where is the order?
But I believe.
Yes, can you give us the instructions? Heard. Will say none appears for the petition on call. Mr. S. Das appears for. SP Das appears for. Respondent number 3. So this contempt petition arises out of this contempt petition is filed by the petitioner alleging willful disobedience of the directions contained in the order dated 3/11/2016 passed in WPC number 3038 of 2015. By the said order, the following directions were made. Page number 51. Considering the fact. So. Where Mr. Das, appearing for the respondents, submits that pursuant to these directions, the case of the petitioner was reconsidered by the SLC. And the SLC, by its meeting held on 23rd November 2017, recommended the petitioner for appointment into the post against the vacancy of 2012 available under the quota for conventional appointments. So the earlier resolution dated 2/3/2015 recommending to resolving to recommend the private respondent from compassionate appointment was withdrawn. Stop. The reasons for the consideration of the petitioner as against the case of the private respondent are elaborately explained in the minutes held on 23 November 2017. So there are, although none appears for the petitioner on call, taking the submissions on record made by the learned counsel for the respondent and also appointing perusal of the materials placed before the court, more particularly the minutes of the SLC held on 23rd November 2017, this court is of the view that the directions contained in the order dated 3/11/2016 passed in WPC so and so has been duly complied with. Accordingly, the contempt petition can be closed. Copy of the minutes are retained in the case records. We keep this or you give us a copy. Contempt petition accordingly stands closed. Notices are recorded.
Item 38.
Order complied. Yes. Where is the direction? Page 8. Learned counsel for the petitioner, this contempt petition arises as it is alleged that there is a willful and deliberate disobedience of the directions contained in the order dated 2/11/2017 passed in WPC 328 of 2017, whereby the pension, it was directed that the pensionary benefits to the legal representative of the Bolendo Ramshiari should be processed by the state respondents as per law within a period of 6 months from the date of receipt of the certified copy of the order. So the relevant portion of the order is extracted below. Para, today, when the matter is called up, the council is hearing for the respondents. One, MSS Condigo respondent one submits that the directions contained in the order dated so and so, passed in so and so, has been complied with. Do you have any communication? She has produced before the board a communication.
Three, 4 and 5 were implemented. The dates.
Hmm.
Serial number 3, 4 and 5 are irrelevant of the meeting. With regard to the pension, it includes the leave encashment benefits.
What are the dates?
Lordship, it's the leave encashment benefit probably was
69.
paid on 69,2019. Then compassionate family pension was sanctioned on 31/12/19, and DRS insurance was paid on 5 communication 5 people.
Upon due perusal of the documents placed before the board to see that leave salary, cash equivalent of leave salary, the petitioner was sanctioned on 16 September 2019. So by order dated 10th of January 2019. But this is not required. Suspension of the, that is not required. By order dated 29th October 2018, the provisional family pension in favor of the petitioner has been sanctioned. Any other order?
Compassionate family pension.
4 and 5 compassionate family bench was released on 31/12/2019 version.
Stop. The compassionate family pension in respect of the petitioner was sanctioned by order dated 31/12/2019. Stop. The GIS accumulated savings was sanctioned, release for GIS accumulated savings was issued on 4th of May 2020. Stop. In that view of the matter, the order directions contained in the order dated so and so, passed in WBC so and so stands complied with. This position is not disputed by the learned counsel appearing for a petition. Copies of the relevant orders passed are retained in the case report. Contempt petition accordingly stands closed. Notices are before.
Item 39.
Considering of the way compact is already given the return, will be the active that is on the report. Area leave, this should be a leave salary or.
Heard learned counsel for the parties, this contempt petition arises out of the order dated 18/9/2018 passed in WBC 4432, as it is alleged that the directions contained in the said order has been deliberately violated and not carried out by the said order. The following directions were granted. For following directions were passed and attained and delivered. Learned counsel for the respondent, Mr. 1 and 2, appearing for respondents 1 and 2, makes that the directions contained in the order has been carried out by And a communication to that effect has been received by communication dated 23/08/2023. As per the said communication, the sanction orders in respect of
Basically.
gratuity and leave. But there are three amounts.
Advance one,
Huh?
one. Advance.
The sanction orders for what payment? Advance.
Basically do in my content, 1 lakh has been added, advance it was given. Out of net amount, 7 lakhs, so 1 lakh has already been released.
Okay.
Total 7 lakh.
The gratuity and
Madam, that is as leave salary and receipt.
the sanction for leave salary and gratuity amounting to a total of
7 lakhs 91.
7,91,203 has been granted by the department, have been issued by the department.
And take the receipt also.
It is submitted that the payment has also been received by the petitioner. So the above statements, these statements are not disputed by the learned counsel for the petitioner. Accordingly, considering taking on record the statements made by the petition, by the learned counsels for the parties, and also upon a perusal of the instructions placed before the court, this court is of the view that the orders, directions contained in order dated so and so passed in WPC so and so stands complied with, and accordingly no further proceedings are required to be initiated under present content case. So content case accordingly stands closed. Notices issued and called. Copy of the instructions dated 23/08/2023 is retained in the court. Content petition close the discussion.
Item 40.
In this case, the incumbent is no more there in the office. Maybe payment for this time. We will get a income back.
Learned counsel for the petitioner begs leave to implead the present incumbent as a respondent. Prayer is made. Prayer for 4 weeks is granted. Matter be listed after 4 weeks.
41.
Even lordships order is at page 12. Relevant portion page 14, para 5. Direction was to consider this case in terms of Upenda judgment and if eligible after making verification, all benefits to be granted. This order is dated lordship 2019, but till date lordship, this is order is dated 1/2019. Till date it has not been complied with lordship.
Yes.
Lordship, the matter may be taken up after some time, Lordship, but serious on legs in another court.
Is it complied or not complied? You have instructions, no instructions?
Lordship will tell you the last date's order. 29/5/2022. His submission was that prayer was made to the government, which is pending, and he sought for time to seek instruction.
Yes, we'll take it up at 2.
Yes, Lordship. All right, Lordship.
43.
Order complied, not.
No, partly combined of this amount that is Lordship.
Notice is served. Who appears?
Real four or six hard. Name of the
Where is Mr. Chisti? Plains Tribes, Commissioner of Finance.
Oh, I was there when repeating, but I've been not there, not no longer with there. Anshuman Sharma is there.
Will you please inform him
This content of.
the content matter? You had appeared earlier.
I appeared earlier, but recently they changed the standing.
Anshuman,
Sharma.
you have to
Son of
inform him.
one, 3 and 4 also.
Mr. Adhor,
1, 3 and 4. Aadhar is also not there, what I believe.
contempt.
अपना क्लाइंट का वो है ना वो तो कौन सा पैसा बोले पैसा है वो फोटो बोल माइनर we have already here the thing minor I'm just placing it on record now I had just click in the अपना टाइम को ये क्या बच्चा आदि नहीं से ये तो दुनिया का डिफरेंट रिपोर्ट से डिवाइस एरिया सारा इज नॉट डिवाइस एरिया सारा इज नॉट माइनर that's it
What is the name of the petitioner? What is the name of the three petitioners?
1, 2, 3, 4, 4, my lord, 4, 5, 6, 7.
Four petitioners. 4, 5, 6, 7.
My lord will find serial number 4, 5, 6, 7, area salary, then gratuity, leave encashment, total. We have already paid in terms of my lord, the petition numbers given.
Salaries. What is the direction? You pay salary.
Direction was considering the fact that I have already directed the payment. Entitlement of petitioner in earlier petition, the present petition disposal, earlier direction of this to respond authority will be needful to release the dues entitled. So this is what my lord the entitlement. The first writ petitioner got 10,64,000. Second got
All right.
14 lakhs. These are the amount value.
I've done 1,000 for the parties. Where is the earlier direction? You are filing contempt petition in non-compliance for which order? 25, 2019 says the earlier order be complied with.
Yes. Property portion test 15.
15.
Yes, 15. Last one.
Page 15.
While the respondent shall make payment of area salary and pensionary. That is, we have paid area salary, my lord. Now they are coming, they want to revise. That's a different cause of action, my lord. We have cleared.
Your prayer before the court at page 14 is to make payment of arrear salary and retirement benefits. Page 14. The small paragraph in between. Petitioner's counsel prays for appropriate direction. And this is the direction which is allowed. Shall make payment of arrear salary, pension benefits.
We have paid area salary.
Area salary.
Engagement.
And leave encashment, gratuity.
Revise area salary, include the area salary.
Area salary. There is no direction for revised area salary, whatever area salary is there.
That is the fresh for cause of action. If they are agreed, they have to come forward with a fresh rate petition.
If you find that you are entitled to some revised scale, we are only closing the contempt petition. Hard learned counsel for the petitioner, this contempt petition has been filed alleging willful disobedience of the order dated 3/6/2016 passed in WBC 6431 of 2013. read with the order dated. 2019 passed in WPC 3132 of 2019, whereby the direction was issued to the respondent to release the area salary and pensionary benefits. So. Mr. R. Hall, learned counsel appearing for the respondents, submits that by order dated 11/5/2020, the area salary and pensionary benefits have been released to all the petitioners. Copy of the communication, copy of the order dated 11/5/2020 is placed before the court, which is also kept in the case report. Mr. Nath, learned counsel for the petitioner, does not dispute his position. Liberty for what? That you'll have to file a fresh cause. Huh? No, both the orders, there is no direction to pay revised case. Direction is to pay area and pensionary, which has been released. Copy of the order is kept in the case record. Mr. Nath. Learned counsel to the petitioner submits that does not object to the, does not dispute this position. As he has no instructions in the matter. So, in that view of the matter, the contempt petition stands closed. Ah. Yes.
My husband died in but he was working in that tax firm. After completing 20 years of service, he died.
Yes.
And fund has not been calculated because only reason that you are not formally regularized. So my respect to commission is central. Because they will having
Yes.
the caption is getting the out because of qualifying for compensation of qualifying terms. Qualifying service is required. 8 years of regular service. By retired. In case of that is hardest. Only 1 year regular service. In my case, my husband that is hardest after completing 20 years.
Your husband was working as what charge? Now,
only very little you are in service which is maintained. He used to get paid on an average. He used to benefit the day pay and also day pay also which is reflected in I am relying on good judgment. In good judgment that employees a period of
what is the judgment?
is paid employee. Case 53. Relevant period, 73 or something. It's 73. 45. There it- There's a point.
Yes,
There is another judgment also. Yes,
Habib Khan.
case 74. Relevant period 75. In this case also. The last one looking for him that. The applicant are entitled to respond the period of works of service for purpose of completion of qualification service for campus.
No, Habib Khan is on, Habib Khan is subsequently they were regularized. This Habib Khan is in the line of Koviram Rajbongsi,
Yes.
where they were regularized, but they did not have the qualifying service.
Regular, but not completed qualification service for 10 years.
That is the same thing in Habib Khan, is it not?
Yeah, it is there, that
Can we read para 3 in Habib Khan?
yes. The period of service rendered by the applicant was directed to be adopted. In property qualification service for purpose of platform. And it says public service revenue. Page number 24 of
So the issue is the period of qualifying service.
qualification service, it is held at works as. Highest period, they also be considered as.
Yes, but in Habib Khan, they were regularized subsequently. They did not have the qualifying service. Yes, Mr. Nayak. Page 73, para 35.
There is another.
Sorry, yes. You're relying on Prem Singh, para 35.
Yes, the have a prayer from the gate. Okay, thank you.
Yes,
In my case, my thinking is very different. I have done the working and in a work. In a second and. Which is reflected in my, it is,
where is the appointment order?
21, thank you.
Yes.
It is photo walks of April.
Hmm. Yes.
And in the agreement also. It is reflected that you are paid salary, that's what they are. And also the ability to pay the public up well to the service.
Yes, let us hear the respondents. That's all?
Yeah, he may be, as I have, you are working in the tax office. So he may be, his service may be regular. What happens for 1 day before the date of the day. It is on our portal, in several cases. I said the authority to regularize the service of the person for a single date.
Yes. Yes, Mr. Nayak, who's that? What is the, we are in the middle of a hearing. Yes, tell us. Tell us. No, no, no. This is already deferred. We have got a list to complete. He was sitting here attending to the matter. This is no way to conduct a court proceeding. Yes, you tell us. Let us wait for some time. Let him come. Yes, please wait for some time.
Take step 2, item number 31.
Yes,
I pray before Roshi. That my union is not the world will be suffering from something. Please assist me.
please.
Please assist me. in this case.
We wanted to pass it over till next week. Your colleague said only for the time being.
Next week.
Matter adjourned for next week. Enabling at the request of the Learned Council for the station.
Item 41.
No, time being. All the time being matter. High level.
Item 24.
You have a strange way of conducting the matter was here, you suddenly disappeared.
I went there to take some judgment.
That's okay, but
I'm sorry.
the middle of the hearing.
I'm sorry.
Yes, he's relying on para 35 of primacy.
Yes. Kindly see it only in the highest quality. In the interest of officer with insurance. Her husband lost it. Both line also. Third line. Behind which he creates some of service. Is hereby appointed as Boxers estate. In the post of city. From Roman Lordship Boxers. So the person. The post against which he was appointed Lordship is also Boxers post Lordship. There is no dispute Lordship. That is why Lordship is prayer Lordship. His first prayer is for regularization of the sun. Is of the Lordship. So he is aware that to be entitled for pension lottery, first his service will have to regularize, only then he will become entitled for pension lottery. In this case, lordship is service was never regular.
That's correct. But he's rendered all the service, his regularization, the fact that he was not regularized,
Yeah.
is not, cannot be attributed to him.
Of the one judgment I am speaking of, that was part of our. One copy I have given.
No, but in the face of the apex court judgment,
Yes.
there is a specific,
The very recent judgment, the first kind is the part, I come to that judgment also. And they see the judgment 15 months 2023.
which judgment?
It is WA 1 2024.
Where is the judgment?
Actually, there also lordship. Petitioners, the lordship, the petitioner here. And the repetition paying for pension. In respect of her husband lordship, whose service was working as workers employee and whose service was never regular. And judgments of our High Court lordship, here with the matter.
Was Prem Singh considered here?
Prem Singh was not specifically mentioned, no,
Yeah.
but from the petitioner side, it was there. If Prem Singh is concerned, lordship will see there, where the basic issue was, whether the work search period or the casual period is to be counted or not for the purpose of qualified certificate. In the Prem Singh,
No, you read 35.
that is the one paragraph, that is what I'm submitting.
No, 35 you read.
Yes, that is clear. But what I'm submitting, lordship, this paragraph is out of context. If your lordship reads that judgment, lordship, paragraph 35. Lordship will be page 73 and
73.
74. Lordship will see
73.
the contradiction in itself, lordship. There are some of the employees who have not been regularized in spite of having rendered the services for 30, 40 or more years, whereas they have been superannuated. As they have worked in the workers established and not against any particular project. Their service, this ought to have been regularized under the government instruction, and even as per the decision of this court in Secretary State of Karnataka versus and others versus Kumadevi 264 and 61. This court in the same decision, not will handle this line. This court in the same decision has laid down that in case services have not been rendered,
Have been rendered.
for more than 10 years. One, without the cover of the court's order. Two, as one-time measure, the services be regularized as such of such employee. It is the fact that once, lordship will get here, lordship, Umadevi was referred lordship. Lordship will know at paragraph 52, lordship, three conditions were there. And the most important condition was working against a substantial vacancy. Sanction. That condition is not there. Relying upon Umadevi's judgment, but only on two conditions, not on the third condition. Lordship, whether this judgment will be binding or not, lordship, that I leave it to your lordship.
It is binding. It is binding. If you disagree, you go and get a clarification.
Lordship, one judgment I can place.
No, you have stopped at this line. You read further.
Lordship.
You read further.
No, the other part, the remaining part is obvious, lordship, that is there.
Then
I have take lordship. But one judgment I can place, lordship, it is also a recent judgment, it was passed after the fencing judgment, lordship. This was in city repeal number, arising out of SLP number 1051. Some sort of 100 pieces, I have only one copy. Not this year, the judgment, not after praising the.
You give him a copy, you get it proposed. Yes, what does it say?
After we say, for regularizer, three conditions of marketing have to be fulfilled. If two conditions fulfilled, one condition fulfilled.
No, no, Umadevi is for a scheme. Umadevi is, if the government wants to frame a scheme as a one-time measure, these three conditions are necessary.
Yes.
But divorce the scheme. Question is, can there be a right?
No, if I submit logic, here also logic, if Umadevi has been referred. It has to be read as the three conditions.
Very well.
And that is why logic in the subsequent judgment logic.
Hmm.
Indeed, judgment has more help.
Has it been watered down? Prem Singh,
Yes, pricing has also been considered. After considering pricing, judgment it was saying that service has not been regularized. It will not be a.
you hand over the copy, we want to go through the order. Vera?
Okay, here the actual rule, so far as our rule and that rule is concerned, not with the technical seminar.
There is no quarrel with this proposition. But subsequently, in the face of this judgment, and perhaps the Gujarat judgment also,
That's not the different what I want. They are getting the physical action. They are interpreting stated, they are mentioning it, you have more than 25 here, and boxers, you will get pension. That is the same. This is one judgment, which 2023, one has 6570. New judgment, here lots of fencing was that. And after taking note of fencing judgment lots, because then that thing not the entire protection.
you compile the judgments, you will not go for a proper hearing in the matter. heard learned counsels for the parties. This petition pertains to grant of family pension. The petitioner who was the widow of whose husband was work charge employee under the respondents. And he superannuated.
No,
He died. Died in harness after how many years?
20 years. 20 years.
20. After 20 years of service as a work charge employee. The claim of the petitioner is that the petitioner ought to be granted family pension as her husband, late husband, had put in more than the qualifying service required under the pension rules. So the learned counsel for the parties has relied on several judgments. Seek to rely on several judgments, and consequently, the matter will require some hearing. List the matter again on 14 September.
Please step to item 41.
Yes, I didn't, sorry, order complied, not complied.
Proposal was sent that is getting rejected. The copy will be given to me.
So the proposal has been sent by the director on 14th of February 23. Serial number 23 and connection 1 is the name of the petitioner. Serial number 23 Nawab Khan Vikas.
Why is it rejected?
So the government has not given a detailed thing. I have communication on 12th of June. The single page is something.
The direction of the court is to implement para 22 of the writ appellate order.
In fact, you consider
Grant of minimum pay scale and other welfare measures.
Logically, kindly come to page 14 of the petition. The respondent authority, more particularly the respondent number 2, shall be at liberty to make necessary verification of the service of the petitioner. And if it is found that the petitioner indeed is covered by the judgment of the appellate court, all the benefits entitled to the petitioner shall be granted to him without any delay. So the authority of the director to verify, and if it is covered, then only to give. In fact, there is no direction that the benefit has to be accepted. Finally, one of the proposals given by the director, and the government has said that they have.
What verification is required?
No, whether for giving the benefit of judgment of the minimum pay scale, whether they fulfill the criteria.
What is the criteria? What is the criteria?
So in fact, the 10 years service. One thing I must submit, the government and the communication is, there is no reason.
Then
The detail.
what is that list? This list is for,
The list is for the persons who have claimed,
more than 10 years of service.
yes, to be the workers, master of technical employee, non-European, and similarly test workers in the women and child development department, formerly known as social welfare department for more than 10 years, and indicated the data of engagement and length of service, and the proposal is set for providing them the minimum payment.
You get your instructions here, it's not very.
In fact, the director is the party here, government is not a party in this case.
This is from the director only.
Correct. Director has already submitted it to the government, now the government has rejected it. So I.
Can you read para 5 of the judgment?
Yes,
Order.
the respondent authority is more particularly the respondent number 2. And shall the respondent who is the director. Shall be at liberty to make necessary verification of the services of the petitioner. Accordingly, yes, verified and sent the proposal to the government. Now the government has. And if it is found that the petitioner indeed is covered by the judgment of the appellate court, all the benefits entitled to the petitioner shall be transferred to him without any fee. That is the right.
So who has rejected this? Principal secretary.
Government, yes.
You go through in,
Yes,
No ground has been communicated, if it is unreasoned, unspeaking lordship, then I cannot challenge it.
we are not here to give you legal advice. You go through this order. You read this along with the directions of this court at para 5. Give him a copy. Please read it.
May I read it loud?
You read it for yourself. We have read it. You read para 5 first of the judgment.
Yes.
yes.
So director has sent the proposal. It is rejected by the appropriate department in the government. So far as the compliance of the order at para 5 is concerned, insofar as director, he has complied the order.
Verification, it is not evident. The direction with respect to verification. Verification of my services.
He has put up a list He's put up a list. Do you disagree with the particulars? Hmm. So what is to be done?
Project verification on their part, it is not evident from this order. So
Oh.
they,
From on whose part?
on the part of response number 2.
So he's, if you do not disagree with the particulars, what verification is necessary further?
But no ground is confirmed.
What ground?
On which ground, upon verification that I am not eligible.
He doesn't say you are not eligible. It is the government who says you are not eligible. It is not the director who has rejected you. Director was direction in respect of respondent 2 was to pull it up.
Lordship, and it further appears from this order that it has been intensive on the recommendation of the finance. Minister, the finance. So, finance was the party in the main case. First case.
You come back to your page number 3 of the petition.
Yes, I have. Direction was only to the response number 2. But finance was also party in the main case also. But from the.
I can give you legal advice. It is your call.
I want to increase because he is. It will be increased notice.
We were waiting for that statement to come. It was not coming. Had learned counsel for the petitioner. He prays for 2 weeks time to file implement petition for implementing further respondents in the content petition. Just after 2 weeks, Mr. Dina, learned senior government advocate appearing for respondent 2 has placed on record the instructions he has received to the effect that the director social welfare has now re-nomenclatured as women and child, Department of Women and Child has forwarded the particulars before the competent authority, who however has rejected the case of the petition. Copy of the said instruction is kept on record. Matter being listed after 2 weeks as prayed for by the learned counsel for the petition. List accordingly.
Unlisted item WBC 4848-23.
Order for a yes.
That is the lordship. My lord, the petitioner applied for a post of Kambura, my lord. The advertisement at page 17, my lord. The page 18, my lord, one condition says that the my lord, the minimum age of the candidate must be 25 years as on 1/1/2020. So accordingly, my lord, the petitioner being eligible, he applied, my lord. And he has been appointed by the order dated 12/5/2020, annexed to page 21, my lord.
Yes.
So all along, my lord, my lord, in all the official documents, his date of birth has been recorded as 5/2/1993, my lord. 5/2/1993. But in my lord, in the mark sheet and pass certificate of Seva, my lord, it has been wrongly recorded as 1/1/1997. So their pass certificate and mark sheet, your lordship will find their page 33, my lord. Page 33 and 34, my lord. Apart from these two documents, in all other documents and in the records of his school, my lord, where from he passed, or in all documents, his date of birth was 5/2/1993. But in these two documents, my lord, his date of birth has been mentioned as 1/1/1997. Accordingly, my lord, he applied to the Seva for correction of his date of birth, my lord. And annexer 6, my lord, page 35, next page, my lord. The it is the certificate issued by the concerned headmaster of the school, stating that, my lord, he is due to clerical mistake, his date of birth appeared in the mark sheet and birth certificate of 2015 as 1/1/1997 in place of 5/2/1993, annexer 6 page 35, my lord. So accordingly, the application has been submitted to the SEBA, my lord, for correction of his date of birth by submitting the requisite fees, my lord, annexer 7 page 36, my lord. So fees of 600 plus late fine of 1400, my lord. Thereafter, my lord, in the meantime, my lord, his appointment has been suspended by order dated 31/10/2020, page 39, my lord. Page 39, because due to this discrepancy of date of his date of birth, my lord. Because if he is 1/1/1997, then he doesn't fulfill the eligibility criteria of 25 years of age. So he has been put under suspension, my lord. Page 39, my lord. Thereafter, my lord, the SEBA has issued the corrected documents, my lord. Page 40, my lord, admit card, corrected admit card, where his date of birth has been mentioned as 5/2/1993, my lord. Then, my lord, page 41, corrected registration card, where his date of birth has been mentioned as 5/2/1993, my lord. Then, my lord, pass certificate as page 42, here also date of birth has mentioned as 5/2/1993, and pass certificate at page 43. So ultimately, the SEBA has corrected his date of birth. And thereafter, he submitted all the corrected documents to the deputy commissioner, and deputy commissioner has issued reinstatement order at page 44, page 44, my lord. He has been reinstated, my lord. Thereafter, my lord, one person filed an appeal, my lord, before the commissioner of North Assam Division Test School, my lord. And the summon of that case, case 45, my lord, first summon dated 27/6/2023. Your lordship kindly come to page 45, my lord. This summon has been issued on 27/6/2023, and the date was fixed on 30/6/2023. It was sent by post. And next page, your lordship will find the total tracking consignment report, where it has been mentioned that the item has been delivered on 1/7/2023, after the date is over. Thereafter, my lord, he received another summon, my lord, page 47. That summon 10/7/2023, and the date has been fixed on 15/7/2023. This was also sent by registered post, my lord, and the petitioner received it on 14/7/2023. Accordingly, he went there, my lord, along with one advocate, but he was not afforded any opportunity either to submit file his written statement or these particular documents, my lord. Your lordship may peruse the order, my lord, annexer 14, page 48, my lord. In the appeal petition filed by Mohammed Salaur Rahman, son of so. In this appeal petition, the learned advocate for the appellant has submitted that an advertisement was issued by the authority for selection and appointment of Gaunpura of some vacant posts, including the vacant Gaunpura post of lot number 3 of village Ketalsor Bihudia, Ketalsor NC of so. The Jalgaon Revenue Circle subject to full criteria of the advertisement, and one of the mandatory criteria is the candidate must be 25 years of age, along with other criteria which also mandatory to the applicant candidate. The applicant and others, including the respondent, applied for being appointed as Gaunpura on the basis of an interview.
Where is that order? 5629/22 order of the High Court?
That order at Mangalore. That order-
29/22, where is that order? This is on the basis of a direction by the court.
No. That was a liberty, my lord. Liberty to file an appeal, my lord.
Whatever it is, where is that
Yes, my
order?
lord. In that proceeding, the petitioner did not receive any notice, my lord. We did not appear, my lord.
But we want to see the order.
Yes, my lord. That order I collected, my lord. But there was only a need to file appeal, my lord.
Now you are challenging this order, appellate order.
Yes, my lord.
Yes, respondent,
Order, it is stated.
Hmm.
Then the peruse the written statement submitted by the parties, it means including the petitioner. And lordship, before that, lordship, heard the learned advocates for the appellate, as well as the respondents. It means both parties were heard, lordship, at that time, before pronouncing the order, lordship. At the same time, lordship, another thing, lordship, which is reflected in, from this great petition, it is base 23, lordship. Base 23 is an, it is a bail order, lordship, which was passed by this honorable court, lordship, honorable Guwahati High Court, lordship. Whereas it is state, it is appeared that he is engaged, he is an accused of a criminal case, lordship. In the advertisement, lordship, in the advertisement, lordship, it is categorically stated that page 23 is the High Court order, bail order, and page 18 is the terms and condition of the advertisement. Lordship. It is categorically stated in Rule 9, Rule 9, the candidate should be the high status holder person of the society. Lordship. Whether the petitioner was disclosed the fact about the criminal case.
No,
not a requirement,
that is a subsequent development.
but it's not a requirement.
And that is subsequent.
There is no condition to say that
Lordship.
any pending criminal matters or any matters to be
Yes,
disclosed.
lordship, he should disclose because the status is required. Lordship. The status.
This order was passed on 11/11/20.
Then,
When was the interview held?
no,
Before that, he was appointed on 12/5/2020, my lord.
12/5.
Thereafter,
but this.
thereafter, my lord,
Case was-
12/5/2020.
Case was on 11/11. 11/11.
This is the bail order, lordship. But
Right.
whether the criminal case was registered before the advertisement or before the.
No, but what is the meaning of high standard?
Yes, lordship.
High society.
High status.
May I clarify that?
Now, hypothetically, you do not consider him to be a person of high status because there is a criminal case pending.
No.
Trial goes on. After 10 years, he is acquitted. Will you now consider him to be high status?
Lordship, in every case, in that every appointment, a police verification is necessary.
Correct.
And in the police verification, if it is appeared that. It is appeared that against him, some criminal cases are pending.
No, it was not pending.
The verification will not come in a positive way.
It was not pending.
Correct, but the verification was not done.
No, but he was not disclosed.
No, my lord, how is not? Please.
He is not required to disclose. Why will he disclose?
Four, my lord.
Unless you set a condition.
Filed after his appointment, my lord.
Paragraph 4 have to come, announce the instruction, whether.
Correct, you will grant you time for instruction.
Kindly tell us paragraph 4, there I have.
Yes, and who is for the, anyone from the private respondent?
No, my lord.
Therefore, private. Who is respondent for?
Seva.
Okay.
So that they can, my lord, submit a report regarding the genuineness of the document. And secondly, my lord, criminal case was subsequent to his appointment. Because if your lordship, there is a paragraph.
All right,
4.
how much time do you require for instructions?
1 week.
1 week.
Yes.
All right, Hart. Yes, what do you say? You are for revenue department. What authority? Huh? Huh?
It is the order of division of the authority will be there. And it will file a review petition before that.
Let us first get the instructions.
In the meantime, my lord, I will.
You want to file a review petition?
My lord, because the efficacious remedy is not there, so your lordship.
We do not know. Hart learned counsel for the notice. This writ petition is filed by the petitioner, who is aggrieved by the order dated
15/7/2023.
17. 15/7. 15/7/2023. Passed in case number 13 of 2022 by the Office of the Commissioner, North Assam Division, Tezpur, whereby in an appeal preferred by the private respondent number 6,
Yes, madam.
whereby
You are even not a candidate, madam.
the order dated 12/5/2020 passed by the Deputy Commissioner Tarong, appointing the petitioner as Gaon Pradhan,
Yes, madam. Gaon Pradhan or Gaon
Gaon Bura. Where is the appointment order?
appointment order at page, my lord, 21, my lord. And particular at page 22, my lord. That's good.
Gaon Bura against the vacant post of Kheteswar lot under Posting Hialmari Moza of Dongao Revenue Circle in the district of Tarong, Assam was set aside and quashed. And the appointing authority was directed to process for the selection and appointment of Gaon Pradhan of the concerned village afresh. Stop. Agreed by this order, the present petition has been filed, praying for quashing and setting aside with the order impugned. Stop. Learned counsel for the petitioner submits that pursuant to the advertisement dated
This is one,
2/1,
2/1/2020.
2/1/2020. Whereby applications were invited for filling up posts of Gaon. Is it in response to this village only or other
No,
villages?
I don't get also, my lord.
Several villages.
Yes, madam.
The petitioner applied for being selected as a Gaon in the Kheteswar. Which village you are applying for?
That is your village.
There are Kheteswar village
Yes, madam.
under Postim Hialmari
Munda.
Moza and Dolgaon Revenue Circle in the district of Tarong. Stop. The petitioner submitted his candidature and was thereafter selected and appointed to the said post by the order dated 12/5/2020. Stop. Meanwhile, the petitioner filed an application before the Board of Secondary Education seeking modification, correction of his date of birth. Stop. His date of birth earlier was shown as 5/2/1993. And that, according to the petitioner, being the wrong date of birth,
No, madam. 1/1/97 was the earlier school. That was wrong.
where is that?
Page 33, my lord. Next, page 33. This was 1/1/97.
His date of birth was earlier shown as 1/1/1997. And because of which the petitioner submitted his application for correction into the Board of Secondary Education. As according to the petition, his correct date of birth is 1/1/1990, 5/2/1993. Stop. In this connection, learned counsel for the petitioner has relied upon a certificate issued by the headmaster of Kanikuchi Niz Origog House High School, where the petitioner was a student, wherein it is certified that his date of birth is 5/2/1993 and was wrongly inserted as 1/1/1997. Stop. On the same basis, the date of birth was accordingly corrected by the Board of Secondary Education in the registration card, as well as the mark sheet and the high school leaving certificates,
And admitted.
as well as the admit card. Stop.
5/2/19. Page 44 is also.
It is to be mentioned here that this correction, during the process of correction, during the period of correction, during the period when the petitioner approached the competent authority for correction of his date of birth, his appointment order was kept in abeyance by the Deputy Commissioner Dorong. Subsequently, upon due correction, when the same was placed before the Deputy Commissioner Dorong by order dated 15 December 2021, he was reinstated in service. Stop. It is submitted that the private respondent filed an appeal before the Divisional Commissioner of North Assam Division as prescribed under the executive instructions appended to the Assam Land Revenue Regulation. Instruction number 167. 162C. Stop.
The applicant was not a candidate member.
In response to the appeal filed by the private respondent, the impugned order dated 15/7/2023 was passed by the appellate authority, interfering with the appointments given to the petitioner and directing the respondents to proceed for fresh selection.
Only on the basis that the petitioner was not 25 years of age.
This order was passed on the ground that the petitioner was not qualified on the ground of age in terms of the advertisement dated
That is one, the 2/1/2020.
2/1/2020, and therefore was not competent to be considered for the post of Gampura as per the terms and conditions mentioned in the advertisement. So. Yeah, Mr. J.K. Goswami appearing for the respondent number 2 and 3, Mr. Your name, sorry? S. Doctor. For respondent number 1. 1 and 2. Only 1. And Mr. Nikhil Roy for respondent 4 and 5. Only 4. Submits that instructions are necessary and they be permitted to complete their instructions. Mr. Doctor, Learned Council, appearing for respondent number 1, further submits that there is an alternative remedy, statutory remedy prescribed under the executive instructions, whereby a review can be filed against the order filed by the appeal, against the order of the appellate authority. So, considering the issues involved, this court at this stage considers it appropriate to issue notice. Accordingly, notice be issued, returnable 4 weeks. Since the learned councils appear for the respondents, notices are waived. However, extra copies will be furnished within 1 week from today. Steps on respondent 5 and 6 by registered post 18 within 1 week from today. The respondents are permitted to file counter affidavits if so advised. The matter be listed again on returnable, make it returnable 3 weeks. On 22nd. Will it be 3 weeks? 3 weeks, 22nd September. Till the next returnable date, the impugned order passed by the appellate authority shall remain stayed.
Deeply.
Then it is for orders, I think 44.
Yes,
Doctor,
yes.
it seems that the respondents have either expired or have retired.
How can you appear? It's already expired. Yes. Last order
So they have to give the new response.
You have to take steps on respondent 4.
Yeah, not okay.
So you tell us what is to be done.
Lordship, I may be allowed to make the improvement petition, to include all the respondents.
Okay, MS,
You shall.
you Sharma, learned counsel for the petitioner submits that she may be permitted to file necessary applications, including the present incumbents in place of the respondents 1, 2, 3, 4. Stop. She prays for 3 weeks' time. Mr. He appears for 1 and 2. This after 3 weeks, enabling the petitioner to file applications for improvement as prayed for. You remain for the time being, let them file the application.
Much obliged.
I think 45.
Order of this honorable police comply. The petition. Petition is issued.
It is submitted by the learned counsel for the petitioner that the directions of this court passed by order dated, which order?
22.
12/2/2020. Sorry, 4/12/2018 passed in WPC 6831 of 2018. Read with the order dated 12/2/2020 passed in 4/22. Contempt petition 4/22 of 2019 has been complied with. Accordingly, he does not wish to press the contempt petition any further. Stop in view of statements made by the learned counsel for the petitioner. Contempt petition stands closed. Notices are defaulted.
46.
This is also relates to the contempt proceeding matter. Subsequently, the order was there at page 20.
Yes,
In the nutshell, my lord, they have to give the nomination of 5,000 per month to the ex Panchayat president. That has not been complied.
we had disposed of Panchayat.
Panchayat.
Who's for the respondents?
Respondent, my lord, I have taken steps, my lord, she will see the office note.
Yes,
Some person have received the notice, my lord, he did not find.
you take steps by Dusty.
Last.
You can take steps by Dusty.
I already appeared, he has received the notice, my lord, but he did not follow. Lordship kindly have a look at the office note.
No, office note is there, but
Who did not return on by this form?
petitioner permitted to take Dusty steps on who is supposed to comply.
Notice was issued to respond number 4 and 5.
4
Who
and
is
5
the competent person?
by on respondent 4 and 5. Within 2 weeks from today. Affidavit of compliance will be filed upon service of notice in respondent 4 and 5. It's after 3 weeks.
47.
If they got to the statement meaning paragraph that you have to take this one. I think it's a maternity benefit on if they are the.
What is the direction?
Page 37.
37.
Last line, Lordship. Lordship, 37 paragraph 1, 2, 3, 4 and 5. These are the direction, Lordship. Now, Lordship, only 5, Lordship. All payment due to the petitioner shall be released thereafter within a period of 4 weeks.
Now 1, 2, 3, 4 comply.
That means, Lordship, my resignation was accepted, Lordship. And now they have to pay me the benefits. That was not paid.
Yes, madam,
They have filed an affidavit, Lordship.
you filed a reply.
Reply, Lordship. My reply, paragraph 17, I have stated that these are my entitlement, Lordship.
All right. MSC guy, Madam. Council appearing for respondent number. Both the respondents please for some time to obtain instructions in respect of the steps to be taken for release of payments to the petitioner as directed by this court. By the order dated
Order dated Lordship 4/9/2019.
4/9/2019 passed in WPC 4075/2019. List after 2 weeks,
Typically fix a date because I have not received anything.
MS Potentially appealed for respondent for the petitioner, list after 2 weeks on 8th of September.
48. Item number 48.
None appears passed over.
49.
Yes, Mr. Roy.
My junior calling up was the petitioner. Whether the payment is received or he is not picking up the phone.
Matter will be taken up after
1 week.
1 week. Enabling Mr. Roy to complete these instructions. List after 1 week.
51.
As far as the office related 25/7, giving more previous 5. Although they are realistic, the direction that goes to correspondent to produce. The order is to be proceeding.
Health department, yes.
One last occasion, I think we will ask for records regarding his prayer also.
Matter be listed for admission after 1 week.
Supplementary list for orders item 58.
Last occasion, was still wanted the council for the BTC to take instructions regarding the compliance of the order of December 4.
Yes, where is BTC?
Now, yes. It is not there.
Where is BTC? Mr. Gogoi, who appears for BTC?
Last occasion,
RB Bora had appeared earlier. Please inform her.
The lawyer's name should also be reflected in the order. So that
It is order, it is reflected,
it is,
it is reflected.
otherwise, for this, so there is.
What is the direction here?
Action was to grant prior approval to the appointment of the petitioner on professional ground. Since he was already selected and posts were also lying vacant, but he could not be appointed because of not having the approval of the finance department. So at page 11, you will find. This is the order. Dated 3/11/2017. And till today, they are just dealing the matter. Professional appointment and that purpose has been prostituted. Paragraph 9. It says, it is a PHU to further division. Four vacant posts in the year 2010 and one appointment has been made, leaving three vacancies. That was the position. With their affidavit have been,
Some instructions were there. Master.
on the last occasion, they produced something, but that was probably communication with the council.
Yes,
That's what I will complain.
Let the officer be present here.
After 2 weeks,
2 weeks after 6 years. Yes, again 2 weeks.
we'll grant you 1 week's time, you give us a status.
But unless they do, we let the officer be also present. for the-
We'll consider that after 1 week. In case we find that. You see, there's a problem here is on every day, different councils are appearing.
That is why I made the. Therefore, can you see the time gap meanwhile? Time they have got enough time. If my learned friends take the responsibility and it will be provided. And then order will be produced on the next day, within a week.
We are giving him 1 week so that he will apprise the court about the status in respect of compliance of this order. That order may or may not be executed, he says 2 weeks. By which date the matter will be. You are giving an undertaking.
After 1 week, we have already communicated to comply with that.
But you may record it and let the compliance will produce.
Right, heard Mr. K.K. Montolana, Senior Counsel, assisted by Mr. S. Gautam. And Mr. S. Bora. Learned Standing Counsel BTC. Who submits that the directions contained in the order dated so and so passed in WPC so and so. Will be. Is likely to be complied within a period of 2 weeks from today. He prays that the matter be deferred and listed after 2 weeks.
But in this 1 week, we'll produce it.
So, considering the fact that substantial opportunities, several opportunities were granted to the petitioner, to the respondents to comply, this court considers it appropriate to direct the matter to be listed after 10 days. On 11th, on which date the Mr. Bora, learned counsel appearing for the respondent, will apprise the court in respect of the steps taken for compliance of the directions of this court passed in order dated so and so in WPC number so and so. List on 11th.
That is fine. Okay, sorry.
No, you are saved by Mr. Borat now.
Item number 33 of court number 10.
Yes. What has happened here?
But the petitioner here is in verge of retirement, my lord. 9 months left, my lord. Now, all of a sudden, he has been transfer order, will be a 10 months. On 9/8, my lord, you will give us take to. Notice, my lord.
Hmm. Then,
And also directed for maintaining status.
uh,
Lord, he's been transferred to a Kubri, Lord.
that order is under status,
Yes,
stay,
it is good.
but this order is not until today. It says until further order. You have not checked the order.
They are also not allowing me to join, my lord. They have.
That's a different issue, but then you have to file an application. You submitted that this interim order is until today. Paragraph 10, do you have a copy of that order? It says until further orders.
Watching that and be within my instruction.
Hmm.
The order was on 9/8/2023 for status total. But on 7/9/8/2023 itself, he was released by. Release order was passed on 7/8/2023. There was surprise, my lord, before the court went.
And who joined in the new place?
No one joined my lord, but he was already released on 7.
So status quo,
Yes, already he has been released, my lordship.
we don't know, that will require interpretation. But as on date, there is a status quo order until further orders.
As.
You have
first
not,
order,
you have
he was-
not filed any application for modification of the order.
my lord, because of the status quo order, my lord. In fact, the petitioner is facing problem, my lord, because already released, my lord.
We can vacate it if you want.
And what I want to.
No, so today we are taking it up at your request because you said it is until today.
Sorry, sir.
So beyond that, anything else, if you require, we decide, otherwise the matter will require some adjudication.
It will, I will let them file an
May
affidavit.
I make some people judgment, my lord?
We are not taking up the matter for disposal. We took up this matter at the request of the council that the interim order is for today.
Yes, yes.
But apparently
I'm sorry.
that was not a correct statement. There are 10 says until further orders. So we'll defer it.
That may be kept, my lord, that may be kept. On the maintenance.
This one, instructions,
Yeah, I'll make it.
yes, take it back.
But that's what we can do.
This had learned counsels for the parties, Mr. Dubey and Mr. Dr. respective counsel. The petitioner has challenged the transfer order. What is the order, date of the order? 24/7/2023. Whereby he was transferred in the same capacity from Binakandi Development Block under Hojai, Zila Porikot, to Agomoni Development Block under Dhubri, Zila Porikot. As the accounts, assistant accounts officer. So. This court, while issuing notice on 9/8/2023, had granted status quo of the directed parties to maintain status quo as on that date until further orders. So Mr. Dr. Leonard, counsel for the department, submits that he was released on 7/8/23, while the order of status quo was passed on 9/8/2023. Be it as it may, since this court had already directed parties to maintain status quo and no application has been filed for modification of the interim order, the matter be listed before the appropriate bench. When? Next week. Please take accordingly.
Item 38 of code number 10.
I made a call to the, Learning Council, Ravi is not responding.
You are appearing for the respondent.
I'm appearing for the respondent, but Krishna, the council is not responding.
The railway, this is by railway,
No, it is MES department.
MES. So this is a review petition.
It is not maintainable unless they have filed it. On arbitrator has already proceeded ahead so much. Or they have filed.
Is there any interim order passed?
It was interim order was passed, Lordship, for staying.
Proceedings.
For staying and reply of me, I have already submitted a reply also. And 2 times has been already adjourned because no time.
But if the petitioner is not, appellant is not there, how do we proceed?
Lordship, kindly, tomorrow is supplementary. Meeting because the arbitration, I too come from Chandigarh as well. It is very much delayed. All the process has been done, only the hearing is to be done. Every correspondence has been exchanged between the parties. And it is in supplementary for tomorrow. Lordship.
Let it be on Friday.
On Friday.
25th.
25th.
Matter be listed on Friday, 25th of August 2023. As none appears for the petitioner. So, Mr.
Ghanshyam Dhiman, Lordship. Ghanshyam, GD Dhiman.
G.D. Bhimal.
Dhiman, DHIMAN, Dhiman.
Dhiman appears in person. Who's the proprietor of the opposite party
Myself the proprietor.
appears in person. Let the matter be listed as prayed for by the respondent in person on 25th.
May kindly be picked in this bench.
No.